I'll let you do your thing.
3:15.
Good morning, everybody. It is 9:30 already. We are going to recess the hearing for just a few minutes, but if you would just please join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Pretty quick, huh? The guy wanted to yak. Let me show you what we did. Like, I don't care. Okay, with that, we're opening the public hearing on Senate Bill 315, and I invite the sponsor to introduce their bill.
Good morning, Mr. Chairman, members of the committee. My name is Shannon Chandley. I have the pleasure and the honor of serving the people of District 11 in the State Senate. That's Merrimack, Amherst, Milford, and Wilton. I bring before you this morning SB 315, relative to law enforcement agency reporting information concerning bias crimes. I am pleased to introduce this bill to the body. I know that you have heard similar legislation. This was passed by the Senate Judiciary Committee and the Senate in the full Senate, of course, and is on its way to you. We know that New Hampshire is a very safe place to live. We hear that often, and we're all very grateful for that. But we also know that New Hampshire, like much of the country, may be experiencing an uptick in bias-related crimes or hate crimes, bias-motivated crimes or hate crimes. This bill is a way to collect that data and understand what it means and how to use it. Of course, that's the point of collecting any data, is to make sure that we can then allocate resources in an appropriate way. Right now, and I should step back and mention that the bill you have in front of you really is a collaboration. It comes from the work that was done with the AG's office, the State Department of Safety, State Police, and some work with the ACLU, and some work with a variety of stakeholders who have interest in this issue. So I think it's very important that we make sure that we're collecting it and we're doing it in a timely fashion. That is one of the things that's so interesting when we think about collection of data, is it isn't useful if it's old. It's better if we can collect it in a timely fashion. So let me just mention that this would require that law enforcement agencies report bias-motivated crimes, hate crimes, to the Department of Safety so that it can then be made available on its website. Currently, the Department of Safety has a very good website, some of it more usable than others, but there is what is called the theme-oriented public site. Right now, the theme-oriented public site includes statistics on drug use and DUI, violent crime, and property crime. But they are planning soon to add 3 more themes, and that would be sexual assault, domestic violence, and bias-related crimes. So in order to have this website up and running and be effective, we need to make sure the data is being collected and reported in a timely fashion. And that is, in fact, what SB 315 does. I'm happy to answer any questions.
Thank you, Senator. Is there a definition in statute what a bias crime is?
Yes. Let me... I'm gonna, okay. So at the bottom of 315, you will see that it mentions protected characteristics identified in either RSA 354B1 or RSA 651:6, Roman 1F. And in that case, in 354B:1, it says, conduct is motivated by race, color, religion, national origin, ancestry, sexual orientation, sex, gender identity, or disability. And in 651:6, Roman 1F, substantially motivated to commit the crime because of hostility toward the victim's religion, race, creed, sexual orientation, national origin, sex, or gender identity. And those include further definitions.
Thank you. And as far as who the officer investigating the crime would be the one who would make that determination?
Yes, and that's a really good question. That is determined, I believe, the FBI definition, and I'm paraphrasing. So, and that is part what defines this is through objective measures and an investigation, a reasonable and prudent person would believe it to be so.
Further questions, Representative Newell?
Anyway, I'm just thinking about kind of the information that it captures and the way that it can be used, right? You're saying we can allocate resources and things like that. And the idea of having something that is a reasonable suspicion from an officer, that kind of gives a little bit of leeway to understand, or, correct me if I'm it kind of gives a little bit of leeway to understand any type of emerging trends and things like that, even if we end up trying to divert people and someone who committed an offense like that one for things around restorative justice and things like that, where it would not be convicted, but it would be something to kind of track and understand what are the trends.
Yes, absolutely would be a way of understanding the trends, and a variety of information would be posted on the website, including clearance of cases and disposition. And I appreciate you bringing up, at least I believe it was yesterday, Representative Selig introduced to the Judiciary Committee her bill regarding a study committee on restorative justice and biased crimes. And I think that the study committee is going to need to be looking at data, and these are the kinds of data that we can use to know whether, is it a problem, is it an increasing problem, is it a problem we need to identify, and how best can we identify? You're welcome.
Representative Selig.
Thank you, and thank you, Senator, for taking my question. So in the language, line 3, it references law enforcement agencies, and then it continues to talk about the law enforcement agencies will make the report. My understanding is the prosecutor for that area is part of the law enforcement agency, or is that different in terms of who's, like, I guess my question is really, could it be the prosecutor who ultimately helps make the determination with the police department about whether it's a hate-motivated crime versus just a crime of passion or something?
I would imagine so, but I think we could certainly follow up on that question.
Seeing no further questions, thank you for your...
Thank you very much for your time.
The chair calls Mr. Henry Klomonovich.
Thank you, Mr. Chairman, and thank you, members of the committee. I'm here on behalf of the American Civil Liberties Union of New Hampshire. My name is Henry Klementowicz. I'm a senior staff attorney. We are in support of this legislation. As the prime sponsor said, it would help gather the data necessary to figure out the extent to which this is a problem, how it's changing, where in the state these things are happening. And mostly I just wanted to commend the good work of Senator Chanley, the Attorney General's office, and the state police for all of their efforts on this. I urge the committee to give this favorable consideration. Happy to take any questions.
Thank you. Questions? Seeing none, thank you for your testimony. The chair calls Victor Muzzy from the state police.
Thank you, Mr. Chairman and members of the committee. My name is Victor Muzzy, captain in the state police that oversees the criminal records unit, and part of that is the UCR subunit within the criminal records unit. Just to clarify, as the senator said, we do have our own state police website. In addition to that, we have the TOPS website, which is a third-party hosted website that we utilize to report crime data and statistics. So historically, that has consisted of, I'll call it, two areas. One area that's kind of geared towards crime analysts and a lot of intricate information that's not really, I can't say user-friendly. It is to the audience that it's intended for. but it's kind of deep stuff, and you got to dig around a lot to understand what you're looking at. And so this TOPS website, as we refer to it, is sort of a more user-friendly public site that will more readily display information in a way that's more easily digestible. And so, pursuant to what the senator said, we do have a project on the plate right now to expand that by 3 additional themes, giving us a total of 6, as the senator had said. So I think it's important to note a couple of things. A, we are collecting this data right now. It's on a yearly basis, not on a 6-month basis, and that's part of the current UCR program that we currently report up to the feds on. The digestibility of the way we present that probably could stand to use some polishing, I'll say, and that's what we intend to do with this project. So I think, Senator, you are correct, and I think the definition as it's been laid before us, because there's some question, right? Is it about a conviction? Is it where do we make the determination that a hate crime is considered that? And so it made sense to me to reference what the FBI uses for that definition, just so there's consistency. And I think we've captured that in the bill here, which is basically, if the officer or someone of reasonable determination to say this seems to be motivated by a bias, just to keep everything consistent. So that all made sense to me. So just to clarify for the members, we are collecting it. Again, and making that available, not in probably the most easily digestible way, but we're working on that. And again, this bill, I think, makes it more readily available in a more timely manner or fashion, I suppose, which is probably a good thing for this purpose. So my intent really, as I think it is right now, is to have a link on our website that points to that TOPS website, so that people know where to go. And I think that will satisfy the bill and will be easy for us to implement, as we've already done with the other 3 themes. So I think that's all I have to add this morning. So thank you for your time, and I'll take any questions.
Thank you, Captain. So on a yearly basis now, you report up to the feds,
Correct.
but do you update your data in real time as it comes in? And then you just transmit that to the feds once a year?
Yeah, well, I think we actually do it on a monthly basis.
Okay.
But we have a state statute that allows us, I believe, until April 1st, the year following, to make sure that those statistics are finalized, I suppose. So we do tend to do it on a monthly basis. That ebbs and flows a little bit. Some agencies are a little bit more difficult to get their data and information compiled. But it's the intent to do that, not once a year, but 12 times a year, or as close there too, and get it uploaded.
So I guess that was just a foundational question. The 6 months won't be a problem then, as far as staffing or getting that in there in time.
Yeah, I don't believe it will really. It's just obviously written down that we should be doing it more frequently. So it will just put emphasis on the local departments, and ours, including ours. Of course, it's twofold for us, right? We create some of the statistics, but we're also responsible for it in the state police. So I think it just puts more emphasis on getting those things finalized sooner and reported.
Okay, and back to the determination piece of this. The officer doing the investigation would check off whether he feels or she feels this is a reasonable determination that this is a biased
Correct.
crime. And that's done. There was a question earlier whether that could be done by the prosecutor or not. That's done in the field, right? That's not done in the court, because you could actually bring an enhanced charge for
Correct.
that, correct?
That's really what happens. Is it might be the crime of criminal mischief, but there's an enhanced penalty if it's bias motivated, and so that's how it works. So I suppose, to answer that question to the best of my knowledge, it certainly could be the prosecutor looking at the facts and circumstances in the case and making a determination about charging that as a bias motivated crime, or that it may qualify. Now, as everyone probably is aware, they could make the determination that although they feel that, they can't prove that, so they don't charge it that way. But that doesn't mean, for this purpose, in my mind, that it still should be reported as a bias motivated crime. There may be some hindrance to them successfully prosecuting it as such, but in my mind, the agency, whether that involves their prosecutor or their command staff or whatever, maybe should be the ones responsible ultimately as a team to determine whether or not it meets this standard and should be reported as such. So
Is the data, though, that you report, is it clear that whether or not a charge was actually brought, and whether or not it was successfully prosecuted?
It's not at the moment, so we would have to consider how to, I guess, adequately capture that between us and the court. Obviously, we share data back and forth with the court now, so that would be an additional couple of steps, I guess. At the moment, our reporting obligation based upon the federal definition and guidelines is once that box is checked, so to speak, and the determination has been made at the agency level that it's a bias motivated crime, that's it. That's where it stops. That determination's been made, it gets reported that way, and there is no real follow through to determine, was it charged that way? Was there a conviction under that? So that would be, I guess, some additional reporting considerations and some communication that would have to be ironed out in order to do this effectively. I see what the intent here is, but it
seems to me the value of the information gets called into question if an initial determination is made bias, and for example, when the person goes to a jury trial and is found not guilty, well, then there was no bias crime because he was not guilty. So therefore,
Sure.
the information is skewed. And at the local level, we want accurate because we could use it for all sorts of purposes, funding, targeted policing, things of that nature. So I wonder if there's a way to add a box or that's going to take you going back. I mean, don't you already follow the cases through to the end, at least as far as your prosecutions? And
well, we do. I mean, the state police does for our own, certainly. You know what I
But
mean?
not this
Not the locals, obviously. But you know what I might see happening is, you know, the court in their sentencing or in their finding may have to check their box to say, you know, whatever it may be, so that we can close that loop a little more effectively. So that's something to consider. You know, and I think the purpose here is to determine at the street level, I'll say that, you know, was this bias motivated? Now, 1,000 things can happen between investigation and successful prosecution, which can change the data or change the way that the data turns out. And, you know, as I understand it and see it, it really doesn't matter. I mean, it does matter what the outcome is because we want to know people are being held accountable to a certain standard. But from an instance standpoint, you know, really what we want to know is how many of these things are occurring in order to how to, you know, adequately address them. The outcome is important, but then we get into what are we really grading here? Are we grading the successful prosecution? Are we trying to determine how things change over the course of that prosecution, or are we really just looking at, is this stuff occurring? Where is it occurring? And what do we feel might be a reasonable outcome, whether that's restorative justice or some other process to reduce it? I mean, I know I'm adding a bunch of layers of complexity to the issue.
I'm trying to get to the value of the information, and the more accurate the information is, the more valuable it is. So if it's determinations on the street level that it's a bias crime, and then at trial a witness comes forward and it turns out that was all incorrect, that information is no longer valuable, other than the fact that an officer made a determination. So it's just maybe something we have to look at further down the road to make the information more accurate.
Sure.
Representative Newman.
Thank you, Mr. Chair. Thank you for taking my question.
Yes, sir.
I don't know if there's a requirement for the locals to report hate crimes now or not, but I'd be curious for what the effect of the 6 months. Do you think you'll get more information, less information? How do you think that will affect what you get now?
I think we'd get the same information. I just think the message to them would be that it's important and it needs to be done more frequently. I can't say that it isn't happening now. It may very well be on a monthly basis when we're expecting these folks to send us their files for upload into the repository for the FBI. I just think it puts emphasis on it to make sure that, you know, if they have a long prosecution or a long investigation or something like that, that, you know, it gets the focus and attention it needs. So I don't necessarily see anything changing from that perspective, just that it puts more emphasis on it to get a determination made in order to report it, you know, more frequently, really.
Thank you.
Representative Selig.
Thank you, Mr. Chair, and thank you so much for taking
Certainly.
my question. I actually have two questions that are related. The first is essentially a follow-up on Chairman Roy's question about if someone's found not guilty, but it doesn't mean that crime hasn't still been committed. It just means that that person was found not guilty
Correct.
of being
Yep.
committed.
That's what I was trying to say, not as quite as eloquently or curtailed, but
And
yes.
if I can ask the second part, which is, with crimes, hate crimes, we know that sometimes are committed by juveniles as well. This data wouldn't extrapolate out juveniles because it's not talking about who's being prosecuted or that. It just would indicate the number of crimes. Is that
Correct. It's
correct?
basically, did this circumstance, set of facts, rise to the level of a hate crime? We're not necessarily tracking on a national level, the age of the offender. We are, certainly, because we know who did it and who the offender was, but not in concert. You know what I mean? So,
Thank you so much.
Representative Muse.
Thank you. So one example I can think of is one that occurred in Portsmouth, where we've had swastikas that have been spray painted on a synagogue. So in a case like that, I'm not even sure they've actually found the person who's done it yet.
certainly.
So under this system, that act, the fact that it was reported that somebody spray painted a swastika on a synagogue, that would actually be reported as a hate crime, not as criminal mischief or vandalism or something like that.
Well, it would. It just has a hate crime element to it. You know what I mean?
Okay.
The criminal violation is just that, criminal mischief, but it's motivated by a bias, which is the determination that can be made, almost immediately, I would presume, upon receiving that call or that investigation. So, and that's, I guess, the distinction we're trying to make here is certainly in my mind, that would be a pretty clear, convincing, and quickly evident bias motivated crime and should be reported as such. The fact that no offenders have been located or determined yet is another piece to that, but
Follow up.
Thank you. And what in your mind is the value of collecting this data, even if we never find the offender and even if these offenses are never successfully prosecuted?
I think education, much like has been mentioned, I don't know who these offenders are. Certainly, it could have been anybody, I suppose. But the juvenile talk has come up, and I think there was some testimony that I overheard yesterday online, and I think certainly the juveniles that have committed this type of offense are looking for some rise out of folks. And is it truly motivated by a bias? I don't know. I would tend to think that, probably the juveniles in some cases have heard that this gets a rise out of people and gets their attention and things. And so I think the value in it is certainly where these things are occurring, who the offenders are, I think will help us understand whether it's an educational issue, whether it's a punishment issue, whether it's there's maybe some other arena we had not considered in both lawmaking and education relative to the topic. So I think it does have some value. The real trouble is, again, determining in some instances like this one, was it truly bias motivated or was it just to get attention, or some other factor? But it will at least help us start to understand, where and why, hopefully, but maybe not fully answer those questions.
Thank you.
Broken. Yeah.
I'm just curious about, the conversation that we're having about kind of what is the standard, right, of reporting. And if we were to require a standard of, a higher standard of conviction or something like that, do you think that in a way that would disincentivize going the restorative justice route for, people who may not need a conviction to be able to have their behavior corrected?
Say that again. Like a conviction. Yep.
Incentivize pursuing a conviction as opposed to going the restorative justice.
Is your question, do you think that the prosecutors would push for convictions versus allowing a plea because that would make the data different?
I'm asking about, yes, basically, but I'm not
giving, assuming bad intent of anyone at all.
Yep.
What I'm saying is just human nature. If you believe that this is something that we need to pay attention to, and a conviction is what would get the information out there and reported, do you think that just naturally that would create an incentive for harsher punishment?
I suppose if we change the standard to be conviction related, yes, and that may very well be why it's not conviction related. It's simply investigation related or at that level. So I think it's important maybe to look at conviction rates or data, but certainly don't want to incentivize that to skew anything.
And to be clear, based on the line of questions I'm hearing, I wasn't suggesting that that would be the requirement. I was suggesting that would be an additional data point. That would be important. Further questions? Seeing none, thank you, Kathy.
Thank you.
The chair calls Sean Locke.
There we go. Now we're on. Chair Roy, members of the House Criminal Justice and Public Safety Committee, my name is Sean Locke. I'm a Senior Assistant Attorney General and Director of the Attorney General's Civil Rights Unit. I'm here on behalf of the Attorney General's Office to lend support to Senate Bill 315. I'd prepared comments, but in listening to the questions, the benefit of going last is I think I'll start with the questions that have come up over this past half hour or so. So I want to talk a little bit about the process. What happens when a hate crime is charged? How is a hate crime charged? So in New Hampshire, any offense can become a hate crime. It is a sentencing enhancement. So it's something that gets added on. It's an element in addition to the underlying criminal offense that has to be proven beyond a reasonable doubt for a person to be convicted of a hate crime. There's no separate hate crime kind of charge that gets brought. It's added on. That means that the prosecutor has to show, as was kind of said at the beginning, that the criminal offense was substantially motivated by hostility towards the victim's what I call protected characteristics. So race, religion, sexual orientation, gender identity, and others. If that is done, the person is then, and the jury convicts the person and agrees, they find them guilty of the hate and crime enhanced criminal offense. It increases the criminal penalty that the person may face for misdemeanors. It rises to 2 to 5 years for most felonies, 10 to 30, and for felonies like murder and manslaughter, it increases the penalties further. But that can't occur if police aren't necessarily kind of being encouraged to identify hate-motivated conduct when it happens. That's the important element. That's the important element in emphasizing the collection of this data, is to kind of allow and encourage law enforcement to look for and look for that hate motivation if and when it is present, if and when it is being alleged by a victim. And, kind of coming back to some of my prepared comments, the timely publication of this data enables my office, go back to the beginning here. 5 years ago, our office issued protocols to aid law enforcement in identifying, investigating, and reporting hate crimes and Civil Rights Act violations. It's a civil statute that I primarily enforce, but works similar to a hate crime charge. We have since been training all new police officers with a 2-hour block of instruction on how to identify potential hate-motivated acts. And one goal in doing that was to improve reporting of hate crimes through the NIBR system, which is the National Incident-Based Reporting System that's used by state police and others to capture this data and refer it up to the FBI. SB 315 takes that goal further. It re-emphasizes the importance of reporting, but also sets additional standards and guidance for law enforcement. Before this, it wasn't necessarily clear when an incident, I think that's some of the conversation we've had here today, when something has to be reported as a hate crime. Is it after a person has been convicted? Is it when it is suspected by the officer? For the purposes of gathering that initial crime data, my office suggested that it should be based on reasonable suspicion, which is when the officer develops a suspicion that this could be, and it doesn't necessarily have to be the investigating officer, it could be up the line. So it could be a detective looking at this case. It could be the prosecutor when the case is referred to them. That develops a suspicion that this could be a hate-motivated act. That's when that data needs to be updated so it can be captured correctly If at some point that suspicion is completely dispelled, there's no evidence, what was initially believed to be a hate crime turns out that it was not the case, that data could be updated as well. But setting that standard has benefits. It ensures that hate crimes are being identified, and those conversations about whether or not this person should be charged with a hate crime is occurring. It encourages law enforcement, and the way I often describe it when I'm training law enforcement is that when there's suspicion of a hate crime, you're not doing a misdemeanor investigation anymore. You're doing a felony level investigation because that person is facing felony level penalties, including significant periods of incarceration. So you have to change how you're approaching these cases to make sure that it is, no stone unturned. Because you're charging someone with a significant offense, you want to make sure you have all the evidence to secure that conviction, but you also want to make sure if there's evidence that says this person should not be charged in a certain way, that you've done that as well. There's also value even where a suspect isn't identified, because it helps identify trends that affect communities across the state. And resources can be directed to those communities to support them, to support those, support the immediate victims, but also those who live, look, worship, love like those victims. Because hate crimes don't occur in isolation. They don't occur, they are message crimes designed to do more and affect people beyond the immediate victim of the incident. They're designed to send messages to the entire community of people who are like that person, to send the message that you are unsafe here, you're unwelcome here. And it has that impact. We receive, or when hate crimes do occur in New Hampshire, or when they are suspected to have occurred, people across entire communities reach out asking what's going on with this case, what's happened here, what can I do to help? But also, am I safe here? Is this somewhere where, like, if something happens to me, are police going to respond appropriately? Are they going to be available? So having this data and understanding where resources need to be directed is valuable in and of itself, even if it doesn't lead to hate crime convictions, because maybe the evidence can't prove that case beyond a reasonable doubt. Maybe, the evidence, there's a plea that is more kind of successful. Maybe there's a call for restorative justice because that is the appropriate response in that circumstance. That may be the case in those circumstances, but those victims and those communities affected still need resources and support. So there is value even in collecting the data, even short of when it leads to convictions. Additionally, the timely publication of this data will enable my office to cross-check our reports and referrals that we receive from law enforcement to make sure that, where people have reported potential hate crimes or Civil Rights Act violations to us, we can make sure that gets reported and gets captured in state police's data. But also where we're seeing data in state police from agencies or communities that haven't reported things to us, we can follow up with them to understand what's going on in those communities. Why was this not reported to us? And one kind of final note on that is, with this bill in mind, with the fact that our protocols have been issued and been promulgated and been out there for over 5 years, or almost 5 years now, we are looking at how to re-engaging with law enforcement, engaging with prosecutors, engaging with the communities affected to see what more where can we take this further? Whether it is, I think there are points of tracking information through from when it's reported as a hate crime through to the conviction to understand where might there be hindrances to kind of taking that case. Sometimes it's plea bargaining, sometimes it's a failure to secure a conviction, sometimes it's a failure to identify a suspect. But understanding kind of what is leading to what might cause the disparity between what is reported in this data and what ultimately results in convictions at the end of a trial. So there's more to be done in terms of gathering this data, but without this data, we can't have those later conversations because we don't even know where we're beginning to figure out where these cases end. And so with all of that in mind, we would ask that you vote ought to pass on SB 315, and I'm happy to take any questions that you all have.
Representative Sitek.
In part of your testimony, you said when you were training law enforcement and there's an element of hate in your crime, that it's now they're doing a felony investigation. Does a misdemeanor get promoted to a felony because of hate, the element of hate?
It doesn't become a felony. I tell them to treat it like a felony investigation because the penalties the person faces are like felony level penalties. So Class B felony is a potential 3.5 to 7 year period of incarceration. A hate crime enhanced misdemeanor is a 2 to 5 year, potential 2 to 5 year period. That's why, yeah.
Representative Harry Gathright.
Thank you, Mr. Chair. Thank you for taking my question. I'm not sure if this question is for you or if it should have been for Captain
Muzzy.
Fuzzy, yes. But I received some data that gave hate crime information for 2022. And I think he mentioned that April is the cutoff for, giving that data to whomever, okay, for the federals. And so for 2023, is that data available now?
So that would be a question for Captain Muzzy, but I know the FBI had, I think, recently released and compiled with the data that's provided by jurisdictions across the country. It's 2022 data. So there is a lag in the FBI certainly releasing the data. I don't know if the state police's kind of portal has 2023 data up on it yet or not.
Representative Salig.
Thank you, and thank you for taking my question, Attorney. You mentioned one use of the data could be potentially directing resources to an area. So in the case where Representative Muse talked about the synagogue in Portsmouth being, having swastikas done, and that one was, actually, they caught the person, but they have not yet caught the person who smashed the windows the other day. Would it mean something like being able to direct additional financial resources for additional security or other measures to protect against those things?
So it can be numerous things. So some of it could be, when it comes to houses of worship, I know that the Department of Safety, I think it's the Division of Homeland Security and Emergency Planning, but they have resources for houses of worship where necessary to improve security or even to do security walkthroughs. And we've encouraged, when we've met with all different communities, particularly communities of faith, to engage with your local police departments to do walkthroughs and security trainings in your building, because if anything were to happen in that church, synagogue, temple of any sort, mosque, local police knowing where things are, knowing where the doors are, knowing where the hallways are, where people could hide, that's value that they won't otherwise have. I mean, I know in some communities, the houses of worship have even uploaded blueprints to local police departments so they know the layout of the space. So kind of having that information can help us foster those relationships, can help direct where, available resources, financial resources to victims. Certainly, depending on the nature of the crime, those victims also may be eligible to apply for assistance from our victims' compensation program. So they could seek recovery of costs for medical care or any other treatment that they may need, or any other loss that they may have suffered as a result of the criminal act. So yes, financial resources is one kind of opportunity, but also, doing outreach, kind of learning what the community's needs are, learning, maybe if there are particular communities targeted, maybe, helping to foster programs and opportunities to kind of bring people together who have been victims of hate crimes and provide support directly to those individuals in the same way we do for victims of sexual assault and domestic violence, ensuring that those individuals have kind of appropriate services available for them as well.
No further questions? Seeing none, thank you for your testimony.
Thank you.
Anyone else wishing to testify on this bill who hasn't testified? Seeing none, I hereby close public hearing. And what's the next? 10 a.m. Open the public hearing on House Bill 321 and invite the sponsor to introduce the bill. Is that his? You're on, okay. Morning, Mr. President.
Good morning, members of the committee, Mr. Chair. For the record, Jeb Bradley from District 3 and Wolfboro. So Senator Abbas was not able to be here today and asked me to introduce this bill, which the Senate passed. And it is part of our bail reform package and was included in the past in bail reform measures that I sponsored. It does a couple of things. Right now, there is a rebuttable presumption that if somebody does not show up for their court appearance, that they can be detained, but it's not mandatory. And that rebuttable presumption comes within 3 times being a no-show in 5 years. And so Senate Bill 321 would change that to 3 times in 5 years and then require, because there have been 3 no-shows, that the person shall be detained. That is the first section of the bill, lines 3 through 8. Lines 9 through 12, if a person is detained pursuant to subsection A, that person would have an opportunity at a bail hearing that that person can submit evidence that the court would decide whether the person has rebutted the presumption, and that release would not reasonably assure the appearance of the person as required. So this is part of our ongoing attempt to fix the issues that we have with our bail statutes. The Senate has passed this provision several times. It got hung up in a committee of conference. I believe it was in 2022. And at that point, Senator Abbas and Senator Soucy, who were the sponsors of Senate bills on bail, decided to split the 2 provisions that we've been considering. The one provision that this committee has done a lot of good work on is the list of crimes for which you would have to see a judge in order to be granted bail. So I just want to say thank you to all of you for the work that you've done. I think the Senate looks forward to working with you as we work through that process. There'll probably be a few questions, but that's okay. But this is part 2 of the efforts to ensure that our bail system is adhered to and that we don't have a revolving door in New Hampshire. So I commend it to you. And again, I want to thank all of you for the work that you've done. Representative Roy, you've done yeoman's effort, but so is the committee, and we look forward to working with you on the other bills that you have before you.
Thank you, Senator. Also, as part of the package that we sent out, that we worked on over the summer, we addressed this as well too. So it's going to be we certainly have a curse of a number of riches to work from all of our work. Any questions for the Senator? Seeing none, thank you.
Thank you.
Anyone else wishing to testify on Senate Bill 321 who hasn't? Seeing none, I hereby close the public hearing, and we will reconvene at 10:30. Okay, we're opening the public hearing on Senate Bill 424. And I recognize Senator Whitley. Oh, there you are.
Thank you, Mr. Chair. Good morning, members of the committee. For the record, my name is Becky Whitley. I'm honored to represent New Hampshire Senate District 15, which includes the wonderful communities of Concord, Bow, and Hopkinton. Today, I'm honored to introduce to you Senate Bill 424. This bill was developed in close collaboration with the Department of Corrections, and it merely refines existing law by establishing a clearer framework for parole eligibility as intended by the legislature. The law as it is currently written is vague and does not provide probation parole officers with legal direction on how to consistently consider parolees for a reduction of their maximum sentence. So additionally, individuals under administrative supervision are only seen once per year, and this bill creates an annual audit system, an annual audit requirement for those cases. So I also want to put this in context. So I was the chair, and two of the members of the committee were on this committee as well. 2 years ago, this legislature created Senate Bill passed Senate Bill 251, which created a committee to look at the adult parole system. It was an incredibly productive committee. We met many, many times over the summer and the fall, hearing from everyone involved in the system, folks who were impacted, folks who run the system, folks who are related to the system, and we came up with a pretty comprehensive report. So in its report, the SB 251 committee recommended the development of clear and concise policy language and parole guidelines to provide greater structure when weighing or evaluating the factors associated with the decision to grant or deny parole. So I'm happy to take any technical questions. I will try to, but certainly the Department of Corrections is here and they can, answer the more detailed questions, but we're not changing policy. We're just taking existing practice, is my understanding, and making it clear in the statute. I think this is good for the folks who run the parole system and the folks who are impacted by it. So thank you very much for your consideration of this bill. And I am happy to take any questions.
Questions? Seeing none, thank you.
Oh, thank you. You guys are easy on me today.
Chair recognizes Jeffrey White.
Good morning, members of the committee. The New Hampshire Department of Corrections is in support of Senate Bill 424. Thank you. I appreciate you allowing me to speak today on this Senate bill relative to the reduction of maximum sentence while on parole. My name is Jeffrey White. I'm the Director of Field Services for the New Hampshire Department of Corrections. And I've been there for about a year and a half now. And it's been great so far. Really appreciate the support we have. The New Hampshire Department of Corrections is pleased to support the bill and would like to thank Senator Whitley and the bill's co-sponsors for its introduction. The bill makes several changes to the law that the department feels will positively impact the probation and parole system. First, this bill refines existing law by establishing clearer framework for parole eligibility, specifically with the reduction of maximum as intended by the legislature. The law as it is currently written is vague and does not provide the probation parole officers with legal direction on how to consistently consider parolees for a reduction of their maximum sentence. This bill has the potential to incentivize individuals on parole by adding additional factors for parole board to consider when making the decision on whether to grant someone a reduction of their maximum sentence. By adding factors such as employment, engagement with treatment, compliance with parole conditions, and others, it encourages parolee to engage in productive behavior and rehabilitative treatment in order to lessen their time on supervision. Finally, this bill creates an annual audit, which Senator Whitley had just referred to, requirement for the probation parole officers to complete for individuals who are on administrative supervision, with the purpose of presenting qualified candidates to the adult parole board for reduction of their maximum sentences. The department currently has approximately 455 individuals on administrative supervision. Pursuant to RSA 504A15, probationers and parolees who have completed a period of active supervision, 9 months for a misdemeanor offense, probation, 12 months for a felony probation offense, or 18 months on parole, may be placed on administrative supervision status if they're not assessed as high risk and have no adjudicated violations. And they're not on placed on parole or probation for a felony listed under Tier 2 or Tier 3 sex offense under RSA 651 B1, Roman numeral 9 and 10. Parolees placed on administrative supervision are required to report annually and must notify their probation parole officer of any new arrest, change in address, or plans to relocate out of state. They also face potential reclassification of their supervision level for any new arrest, conviction, or significant noncompliance with their probation or parole conditions. By adding the annual audit requirement for the probation parole officer to review the individual under administrative supervision, this has the potential to increase the number of deserving individuals appearing before the adult parole board to have their maximum sentence reduced. This in turn will decrease the caseloads of the probation parole officers, allowing them to dedicate essential time and resources to those individuals on supervision who need it the most. Thank you again for the opportunity to speak in support of Senate Bill 424. I'm happy to take any questions that you may have.
Thank you. Could you give us a hypothetical
Okay.
parolee and just kind of walk us through how this would apply? So someone is incarcerated for whatever. They become eligible for and are granted parole. That's when this new legislation would come into effect.
Correct. So if you were sentenced to, say, 2.5 to 5 years in the state prison,
Yeah.
at the 2.5 year mark, you're eligible for parole. You go in front of the parole board, say your piece, and hopefully granted parole. Now you're on community supervision, which is being supervised by a probation parole officer in the community. When that happens, as long as if it's a felony level offense, if they're on supervision for 18 months and they're basically low, not really a high need person that needs to be supervised on a daily basis, a weekly basis, or but even a monthly basis, they could get reduced down to administrative status. As long as they're rated as a low, which, like I said, is a real low need. We trust the fact they're doing the right thing. They're gainfully employed. They have family support. They're not housing challenged. They have food. They're not hanging around with the people that they were potentially. No substance use issues, or they're dealing with treatment for it. Mental health issues are being addressed. So once you've been on administrative supervision for about 18 months, that's when we'd like to look at somebody and say, okay, this person's doing all the right things. How do we reward them? How can we help them better themselves and let them continue on the right path, which is our goal, rehabilitation, and getting people back to society, to being productive. So at that 18-month mark, we want to be able to look at and say, okay, this person deserves a reduction in their maximum sentence, would be that 5 years, because you're on supervision from that 2.5 year mark to 5 years. So 2.5 more years on supervision as a parolee. If we see they're doing well for 1.5 years, well, then we can knock some of that time off and say, all right, we've done our job. We've helped rehabilitate this person. We've given them the guidance and the tools to be productive. Now, let's let them free to see if they continue on that path.
Okay. So after a successful period on administrative parole,
Yeah.
then this would contemplate looking at, okay, so we can take up to a third of your remaining parole time,
Correct.
and you're all wrapped up.
Yes.
You're good to go. And this statute is giving guidelines to both the parole officer and the parole board as to what they should consider when they're considering giving that 1/3.
Yes,
time.
it gives you the time periods, and it also gives you the amount that they can reduce.
Okay, great. Any questions? Representative here at Guthrie.
Thank you, Chair. Director White, how many people did you say are eligible now? 400 and something?
There's approximately 455 on administrative supervision currently.
Okay, thank you.
Other questions? Correct me if I'm wrong. So many of our benefits and even things that would help someone clear their record, there's a time period that tolls, and that doesn't start to toll until the sentence is complete. And
That is
part of that is their parole or probation. So the earlier they get that done, the sooner they can qualify for certain things. Is that correct?
That is correct. Once they've wrapped up their sentence, then the time starts before they can consider seeking out an annulment to remove their record.
Okay, so that's a reward in and of itself, is
Yes.
that you can, not only you don't have to come see me once a year, you also can begin the process of getting your record cleaned. and
Yes,
getting-
a little bit earlier. Absolutely.
Okay, thank you. Seeing no further questions, thank you very much.
Thank you, sir. Thank you all.
Anyone else wishing to testify on this bill who has not testified? Seeing none, I hereby close the public hearing. We will reconvene at 11. We are opening the public hearing on, where is it? Senate Bill 426. And I invite, who do we get?
Gannon.
Senator Gannon to introduce this bill.
Let me turn on the mic here. I'm Senator Bill Gannon. I represent District 23, a beautiful area in Sandown to Seabrook, and commonly known in my area as the wine region. Come on down to Sandown. We have great wines at Torino's. That's my little plug. It's supposed to be funny. Tough crowd. So this bill was, I brought it on behalf of the police chiefs, and the reason we brought it forward is we're concerned with impaired driving on the roads, especially poly-use driving, but I won't get into that too much, mix of alcohol and drugs at the same time. But deaths are up, accidents are up. They even found one guy a couple months ago in 93, 2 a.m, passed out in his car in the middle of the road. So I'm concerned with the safety of all of us. I have 4 kids. I want them safe out there, and I want your kids safe out there. Surrounding states have done this type of law: Massachusetts, Vermont, California, Colorado, Illinois, Washington State, DC, amongst others. So the idea is it's sort of like a wingspan rule, which is a common idea in law, that you try to keep everything as far away from the driver in his wingspan as possible. It's more used with guns and other stuff, but it's the same concept. So I've been told for years and years, everyone wanted to treat marijuana, medicinal or whatever, the same as alcohol. So we won't talk about medicinal at the moment. We'll get to that in a second. But if you have a container of alcohol, you can't have it sitting next to you when you're driving in the car. You have to have it as far away as possible. So ideally, if you've opened a container of gummies or whatever you have, any type of marijuana, ideally you'd place it in your trunk. You might have a pickup truck. You can't do that. So we want you to place it, again, as far as possible, under the back seat, in the glove compartment. If you only had a cab, truck, it would probably be under the passenger seat or in the glove compartment. But again, trying to keep it out of reach of the driver. Same idea as alcohol, an open bottle. You keep it as far away. Certainly you don't have it next to you in the seat. So we were concerned, and you guys have 20 people. We only have a few in our committee. So there was concern now with people having therapeutic cannabis cards. How should we treat them? Because it's now a medicine. It was brought, so we did an amendment to say, if you have a cannabis card, we would try to treat that like a prescription drug. So that's a little gray area that I don't think we handled it quite well in our amendment. We have an amendment, and the idea was to treat that like a drug. You could have the open container, because if you had an opioid prescription and you took something, so it's a little weak, because then you're going to treat marijuana differently in two situations. But we really couldn't figure a better way around it before we got out of committee. So the best we could do was this amendment to keep both sides happy. It did go through, I believe, 5-0 in committee, and I think it went fairly well through the Senate. I'm not sure if it was unanimous or not. But again, so that would be the only area, if you guys had better thoughts than we did, as to amending it for someone with a prescription cannabis card. Because again, I don't want them really taking the gummies either while they're driving. So it's sort of I saw the flaw, especially last night when I was looking at this. I'm like, oh, we didn't really do it. But that's why we have you guys, to clean up our small little errors. And that is about it. And I look forward to any questions. And I don't know if law enforcement's going to testify after us, but they may be.
Thank you, Senator. Was there any thought given to just treating it exactly the same as alcohol?
I've brought this bill forward before, and it was always exactly the same as alcohol. Because now it's going to have there's potential problems with someone you had the open container of gummies, and you're like, oh no, that's my medicine. I take that for, but it still can, raise your THC level and make you high. So again, it's a safety concern, but last minute, we didn't see a better way of doing it. The Therapeutic Cannabis Board came forward, and they brought to a couple people's attention that we were treating this not as a medicine if you had a therapeutic card. In years past, again, it's 2 or 3 times come here before, just straight out treat it like a, you know, an open container of alcohol, keep it out of reach as far as possible, whatever part of the vehicle that would be.
And with, I was hoping law enforcement was going to testify, but with regard to the law enforcement concern that they wanted you to bring this, what is it? They're finding, obviously, with the guy passed out, that was probably opiates, but what is their concern, that people are smoking and driving? Is that
A lot more. So like 2 out of 3 accidents, especially, it's even higher, I believe, in crashes. It's about 66% are poly use is now the common thing. You know, you're drinking and you're smoking. They're finding that as one of the most common. But I mean, you could just be drunk and impaired, and you could just be stoned and impaired. But poly use seems to be a very big problem at the moment. So at the accident scenes, that's what's they're finding. 2 out of 3 is a poly use, and which I understand, because as an attorney, it's bothered me that if you're drunk, we can get you with the .08. And again, get you means I want the roads to be safe. It doesn't mean that I'm after anyone for using. I personally don't like either one too much, but again, I've probably been at accident scenes too many times. What was your question, Maura?
so?
So law enforcement has
Yeah.
come to me, and Commissioner Edwards testified in the Senate on it. I had a lot of law enforcement testify then. I'm sorry, I used up all their time, I guess. But yeah, the accidents are going up. They're stopping people. And we had someone in one of your committees last year who said they were using gummies I believe it was last year, while they were alive. And it just, people don't take it serious enough. I don't mind what you do recreational at home, or if you have a condition, you got a medical card, that's great, but you can't do it when you're driving.
Or
Accidents
legislating.
are up. And again, the police have reported about 66% increase in usage, and they're having problems. So we just want the roads to be safe.
Okay. Any further questions for the Senator? Yeah, Representative Newell?
Thank you, Mr. Chair, and thank you for taking my question.
Thank you.
I'm curious about, with alcohol, it's very clear how it would be a sealed bottle. But how would we ensure that, just in the ways that I've seen, the purchase of marijuana, if it's, how do you ensure, is it sealed, and then you would be able to tell if the seal was broken?
Again, so I probably have less familiarity with the packaging than I should. Talking about it. So I don't really know what the patch. So if you had ideally you had an open container of anything, a bag of gummies, you'd put it in the trunk. You don't have a trunk, put it under the back seat. Senator Abbas was concerned then, well, geez, my kids might be in the back seat and you're putting it. So there are always concerns, but we're just the furthest point away from you is our ideal thing. Glove compartments, everyone seems to have one. So if it's there, it's not so hard for you to get when you're getting out of the car, but it would be pretty hard to get to if you wanted to get them while you're using them.
Okay, thank you.
Again, our thought is glove box is like a nice safe area if you don't have a trunk.
Can I follow really quickly? And I understand
Sure.
that makes sense to me for it to be out of reach.
Yep.
Absolutely. But it does include the language, the same language as alcohol, which would be that it needs to be in a sealed container. And that would be something that makes the difference in here. And I think that might not make sense in the case of marijuana.
Can you explain the packaging to me more? So here we got our bottle, right? We got a cap on. You don't want that sitting next to you. You want it, at least if you had that open whiskey bottle, have it under the back seat. So the officer pulls you over, he knows at least you don't have it there. And they'll say, have you been drinking? You might say, I have a bottle. It's under the back seat. What is the packaging like with gummies? Is it Ziploc? I'm not familiar. I'm sorry.
Often, yeah.
There's no law that says you have to keep it in the original packaging. So
No.
like with prescription drugs,
Yep.
I believe there's a federal law. I'm not sure if New Hampshire statute mirrors it, that you're supposed to keep in the original drug with the prescription on
Yep.
it. Since this is illegal federally, that doesn't apply.
Yep.
So someone could get a package with a seal, open it, and just take a couple, put it in a baggie, or whatever they want. So it's really difficult to focus on the packaging as much as the wingspan, as you
Sure.
discussed.
Sure. Okay.
Thank you
Does
for
that make
clarifying.
sense?
Yes, I
Yeah.
appreciate that.
Thank you, Rep. Newman. No, so I'm relying on you maybe to tweak.
Representative Salig.
Thank you, Mr. Chair, and thank you for taking my question.
Thank you.
I know, like, when I've been prescribed medication from my doctor after post-surgery,
Sure.
it always comes with the label saying, do not drive while using. Do we have, is there anything with medical marijuana, and you may not know the answer to this,
don't.
but that would have a similar type of warning label, like it's not recommended to drive while using this product?
Not sure. You guys may know more than I.
I think when you get the card, they may emphasize that, but I'm not sure. I see you, Representative Muse, but first Representative Murray. Okay, well, she waves off. Representative Muse.
Thank you. I just want to verify. I see
Sure.
that the Senate did amend the bill,
Yes.
the original bill. And I think the part that was amended is right up front, where it says the word marijuana is used in this section shall have the same meaning as defined in RSA 318B and shall not include therapeutic cannabis. So, am I understanding?
You are correct.
I'm
So-
understanding that this doesn't. This therapeutic cannabis would not be included under the scope
We
of
were
the bill.
not treating, yeah, it was
Okay.
Senator Whitley and the head of the therapeutic cannabis came up with this language that was acceptable to the majority, so.
Okay. Thank
I
you.
wasn't really part of that negotiation.
Seeing no further questions, thank you, Senator.
Thank you very much. Have a great day.
We'll see what we can do with this. Chair calls Representative Heath Howard.
Thank you, Mr. Chair, and thank you, committee members, for having me today. My name is Representative Heath Howard. I represent Stratford 4, which is the towns of Stratford and Barrington. As of right now, I'm neutral on this legislation. I support the intent. I think that the intent is good because we shouldn't have people impaired while they're operating a motor vehicle. However, I do have some worries about some of the specifics in the language, especially as it relates to the original container and the unbroken seal. Especially if, somebody is going to somewhere else outside of their original private property. So if somebody owns, say, 2 homes and they're transporting their therapeutic cannabis, for instance, up from that first home up to that second home, they could not potentially have the original container with an unbroken seal. And so I think that could pose a potential risk for people being unintentionally charged with something that they were not necessarily intending on doing in the first place when they may have been trying to follow the law as closely as they could. When it comes to Representative Selig's question about whether or not there are labels on the therapeutic cannabis products, there are warnings saying that you should not operate a motor vehicle. I believe that there are a few others. I don't have the warning label on me at the current moment, but I could definitely get you some additional information about that. If you'd like more, I can contact you after the committee. But that being said, there I think needs to be a little bit more of a broader language to kind of generalize things that still kind of shows that the driver is intending on trying to keep the cannabis products as far away from them as possible. I'm open to any questions. Thank you.
Representative Mannion.
Thank you, Mr. Chair, and thank you for taking my question. This is concerning your issue about it being the partially secure or open container, maybe in different packaging. And I might be wrong, but the way I read this is it says securely capped, partially filled containers of marijuana or marijuana in any other form of unsealed packaging shall be stored or transported in the trunk of the motor vehicle. I think that satisfies your concern with that.
Yes, but as we had heard, not necessarily every vehicle has a trunk. If somebody has a truck, for instance, putting it in the bed of their truck is not necessarily the most feasible option, especially if they have a single
I think it says
cap.
glove box too, doesn't it?
Yeah.
Yeah.
If I just follow up, and that does say that if you don't have a trunk or whatever, you can, wherever is least accessible to the driver is a place you should keep it. So
Yes.
if I interpret this correctly, I think that satisfies your concerns with the bill.
Yeah, I just I'm a bit wary of the specific language and how we need to go about this just a little bit more generally rather than kind of referring to specifics about where the driver should be placing it and just kind of stating that it should not be within their reach. Thank you.
Thank you for your testimony. Anyone else? Anyone else wishing to testify on this bill who has not?
Oh, what, did you have a question?
Oh, no? Okay. Seeing no one, I hereby close the public hearing. That I open the public hearing on Senate Bill 653, and I recognize Senator Gannon to introduce this bill.
Thank you very
Excuse me,
much,
563.
Mr. Chairman. Thank you all for having me today. I'm Senator Bill Gannon. I'm from Sandown, again, from the wine district of New Hampshire, spanning from Seabrook to Chester, but not forgetting Sandown. I come today before you. I'll tell you why we got here. I go to a lot of town fairs in the summer. You guys all probably do door knocking and stuff, but town fairs are one of my big things. And the last 2 years, everybody who's come to my booth, 2 out of 3, it's immigration. They want to talk about the open border policy. Number 2 is the economy, but number 1 seems to always be immigration, more and more so lately. So my constituents have come to me from pretty much all 12 towns, and they've said to me, you know, the federal government's not doing anything. As a matter of fact, they feel that we have no border at all at the moment, and that we're suffering the effects, as we've seen in Massachusetts, where they're now housing people right near where my daughter lives at the Reggie Lewis Center. They've entered out their main facility that the community uses for senior work, for tons of stuff they do at that Reggie Lewis Center, and it's full of immigrants now. In fact, the governor of Massachusetts went so far as to say, there is no more room. We need people to volunteer and start taking people in. It comes very close to New Hampshire. Senator Abbas, his community down at the Methuen border, I believe it's a Ramada Inn, an old inn. They took over the whole thing. So 1/2 mile from our border now. And the problem is not the people themselves. I'm sure most of them are looking for a better life, just like all our grandparents and great grandparents were. And they're here to raise their families and live an American dream. Unfortunately, they're not being vetted. And so mixed in with those, as Homeland Security has said, are hundreds of there's people on the terrorist watch list. We know people are being coyotes, bringing people in. It's bringing enough fentanyl to kill us all in the whole country is coming through the southern border. So it's a problem that's made every state a border state. According to the Committee on Homeland Security, it costs approximately $481 billion per year to feed, clothe, house, educate, all the expenses associated with the 10 or so million people who have come in the last 3 to 4 years. And again, our main problem is they're not being properly vetted, so we do not know who's in the community. So who would that be? That would be people like we had the man in Rye, who was a mass murderer from Brazil, who had executed 12 people in Brazil, but he was living and working amongst us, driving from Merrimack every day, working to his painting job in Rye. It also includes people like in Dover. We had an arms dealer living in plain sight, and he had come over illegally. We've had rapists, we've had coyotes on the Canadian border. It tends to be a magnet for problems. And again, we have watched our other states. We're watching every night. If you turn on the TV, we're watching activities of the bad. And I admit it's probably not representative of the crowd, but we are seeing, we just can't handle this flow. We could handle a much smaller flow of illegal immigrants, but it's a problem. So this bill focuses on a very small area, but that's why we're doing it. That's why we brought the bill. We don't want New Hampshire to become like Massachusetts, New York, and these other states where the governors, their mayors are saying, we can't handle this. We can't handle the cost. We can't handle the security. And if we allow a sanctuary city, I know we're a local, we'd like to think we're a local control state, which we're not. But if the town of Lebanon, which has a welcoming ordinance, which anyone else, by whatever term you want to use it, it is a sanctuary city ordinance, as does the town of Hanover, as do several others. And so just because you use the word welcoming, the problem I have with these ordinances is that they tell the police officers in the department they shall not cooperate with the federal authorities at all. They shall not disclose information regarding citizenship or immigration status. They won't let it, not to allow anyone into the police facilities to interrogate. They're not supposed to even make the phone call. If they do, a police officer thinks that in the public safety, they risk being fired and sanctioned under these welcoming ordinances. So what we're asking people to do, if a police officer is pulling someone over, say they were pulling a DUI over, and the person either tells them or that comes to their knowledge that the person is not here legally, we want them to, and then they find out there's a detainer notice. They comes up on their screen, says detainer wanted by ICE, Homeland Security. We're not asking them to do much. We're asking them to make a phone call. It's going to cost 10 or 15 cents. I'll hand them the dime or quarter if they need it. But that's all it is. And they're going to call Homeland and say, is this a bad hombre? Is this someone we need to deport? If it is, we're not asking the police to go enforce federal laws. That is not at all what we're asking. We're telling them, can you cooperate? These towns and these two ordinances do not cooperate with the federal government in the detainer notice. So if there's a detainer notice, they make the phone call. It's a de minimis cost at best. They hadn't gone out. We're not hunting anyone down. It's if they find out in the middle of an arrest that the person is wanted by one of the federal agencies, make the phone call. And if they say, that's no one we're interested in, a lot of the time they're going to say, it's an inconsequential person. There's no risk at all. And they will probably just release that person. If they say, no, that's the next 9/11 terrorist. We have him on a watch list. He snuck over the border. We have pictures of him. Then they have the option then to come pick them up. The detainer, they can only hold the person for 24 hours. So there would have to be a federal detainer notice that was issued, Homeland, ICE. They have to have probable cause to believe this person is subject to federal prosecution. So the other part would be that maybe people argue that it's going to be a big expense. What if we have to house them for the 24-hour period? Actually, there's a federal facility in Dover. I talked to the governor's security guards. I was asking about this. I said, you're state troopers. And they said, oh, in the past, what we've done is we just dropped them off in Dover. And then we were done with it. So the costs are very small. A brief detention, you're probably already detaining them on the state charge anyways. So we don't feel it's a burden on the police. We're not forcing them to do anything big. They did have some of the cities. Again, we have two different worlds in some ways because my suburbs have probably different feelings than the cities. The city of Manchester and some of, we'll just say the more blue-leaning cities have signed and said they're against this bill. But then I've talked to some of them and I got the Manchester Police Department to give me their operating procedure. And their operating procedure says that they will cooperate with federal agencies and they're not bothered by this. So if they follow their operating procedures, their procedures say cooperate with the federal government. So was it political in this sheet that they come up with 12 towns? I've talked to a lot of people in law enforcement in my area, be they local, they're mostly local police chiefs, and they say they have done this. My own chief in Sandown said over the last 20 years, he's had 3 or 4 stops. He's called ICE or Homeland once or twice. They've come and picked the person up. There was no major expense to him or my town. And I didn't want to read you my testimony that I did in the Senate, so I've just been going off the top of my head here, so I should probably slow down. And again, it's the safety, the public safety is our biggest issue. If they were vetted and we had a smaller crowd coming in, it would be one thing. But we don't. Again, we have people who have been bad actors in our communities already. I just read you the tip of the iceberg of what I could have in the last 4 years of people who've come into New Hampshire who shouldn't be here. Again, this in the north, in the Canadian border, he was a coyote. It was the second time trying to run people in. He had been caught in 2011. Who knows how many times he wasn't caught. This was, I believe, last fall. And I'm not saying I'm not a particular big one on the Canadian border. My biggest thing is just in general. Some people are specific and are very into the Canadian part. I believe most of our illegal immigration is coming from the South. They're being bussed up to Boston or something. And again, is it as big a problem here as it is as you go south? No. But once people who get into our country, again, I believe every state is now a border state subject to these people. Someone could go anywhere in our country. Travel is very easy. And we would rather New Hampshire not become a sanctuary state. And I think that's enough.
Thank you,
Any
Senator.
questions?
Senator, with regard to the towns you mentioned, like I think you said Lebanon. So is it the current policy, and your understanding, that if they're booking someone for a New Hampshire crime and there's an ICE detainer, say, for rape, that they're not allowed to call ICE?
Oh, under provision 7, I just happened to pick one town over the other here, Lebanon. I can leave you these. No agent or agency of the city of Lebanon, including law enforcement, shall cooperate or participate in immigration enforcement actions as an agency authorized to communicate with the federal immigrations. Yeah, it's very clear that they're being told not to cooperate, not to make the phone call, not to do any affirmative action. So again, we don't want them enforcing federal law. We just want them to cooperate, and we think that cost will be de minimis.
Thank you. Further questions? Representative Muse?
Do we actually have any statistical evidence of how many crimes are actually being committed by people who are undocumented, and how that actually compares to those of us who have lived here all our lives?
So yeah, Senator Whitley has interesting statistics, and she will tell you that an American is 3 times more likely to commit a crime. But I can explain why her statistics are flawed. They do not look into the fact that a lot of cities have been aware for years, if they go to prosecute someone in a courtroom, they will be deported because ICE will come. In Boston, they will release them out the back door. It's anecdotal evidence. I don't have specific cases, but yes, around the country, your bluer states do not want to keep records of, and they let people out who are charged because they know if they go for a felony charge or something, ICE will show up and deport the people. So the records aren't really kept as far as how many. They let them out the back door. So they're statistically now, because I don't think anyone would believe. I'm not saying these people are better or worse, but they're not being charged with the crimes that would get them deported because the judges are aware that this deportation will result, that Homeland will show up, that ICE will show up. So they release them before these things happen. Just like they're told to in Lebanon and Hanover. They're told to not cooperate, not to make those phone calls.
Follow up?
Follow up.
So I didn't hear anything in there about any evidence.
So I don't have statistical evidence one way or another that they do more or less crimes, but
Thank
the
you.
statistical evidence that was released in the Senate was flawed evidence because Senator Whitley only brought a skewed study forward.
Representative Newell?
Thank you, Mr. Chair, and thank you for taking my question.
Thanks for talking to me.
I'm wondering, okay, so I see on page 3, starting at line 10, this section does not authorize a law enforcement agency to detain an alien unlawfully present in the United States pursuant to an immigration detainer solely because the witness reported a crime or was a victim of a criminal offense. And it continues on to talk about domestic violence, to talk about rape, sexual exploitation, sexual assault. These are commonly used when people are in support of sanctuary cities. This reasoning is commonly used as people will not be able to report a crime, will not feel comfortable interacting with law enforcement if they have the threat of something like this. Do you feel like having this section in there would negate people's fear in interacting with law enforcement?
Yeah, so there is somewhere in there. I haven't read it in a few weeks. I apologize, but there is a section saying that if you report, it was to. We had a lot of Brazilian community from Nashville come to our hearing, and it was pointed out to them, and they came and met with me after that. If you do report a crime, that you'll even be helped to work towards. You have like a 2-year period that they will not report you to Homeland or ICE, and they'll even try to help you get citizenship if you report a crime. So it's to get people not to be scared of reporting. So they are covered there, but I will have to read this again. It's just been a little while.
Representative Harry Gathright?
Thank you, Mr. Chair, and thank you for taking my question. On page 2, line 27, a lawful enforcement agencies shall use best efforts to support the enforcement of federal immigration laws. Can you describe to me what best efforts mean? Is that just a
It
problem?
just means, yeah, so we want them to make that phone call or to drop them off in Dover. If they call Homeland, call ICE, let them know. That's all they have to do. They're just not to we would like them to cooperate. to the best of their efforts. It doesn't mean they're going to hunt down dishwashers. And in Portsmouth, Senator Perkins spoke always, it's like, I'm a welcoming community. And I'm like, no one's coming to your community to go after immigrants. They're coming, we just want to keep the immigrants community just as safe as us. And so we do have provisions in the bill to assist people who talk to let law enforcement know that there have crimes, have been witnesses. And again, best efforts will not be, you might hear that it's going to be cost a lot of money. Again, you make that phone call is all we're asking for. Detain them in your jail for whatever brief period that is, or if you can't do that, drop them off in Dover at the federal facility.
Follow-up.
Follow-up.
Today, if someone's arrested, doesn't matter who they are, but if they believe that this immigrant that's arrested and they're booked, do not they already know if ISAC has paperwork out for them?
Yeah, they would know if they run the name through and someone gave their right name, and it pops up that they're wanted by ICE. Yes, they would know, and we want the police then to make that phone call.
Okay, follow-up. One last one.
Follow-up on the follow-up.
Okay, so, but what you're asking is that our law enforcement do the work of ISAC by making that call.
I'm not asking them to go out and arrest anyone. I'm not asking them to spend or use any resources other than you've encountered someone, you're doing with the state offense, you've arrested them, brought them in, and you know that they've either told you, somehow you ran their name and it came up on Homeland, so you're aware, and now you're going to inform Homeland. We have Bill Gannon in custody. Would you like to come pick him up? And if they say no, you release them.
Who's next?
Thank you.
Further questions? Representative Muse.
One of the things that the bill seems to require is for police officers to make best efforts to contact immigration officials. One of the things that I'm curious about is you seem to say that's limited to just making a phone call. I mean, and best efforts really isn't defined in the bill in any way. So is this sort of a thing where we just sort of make it up as we go along, depending on what the situation is? Or do you think we actually need to have some real standards in the bill around what actually constitute best efforts?
Well, if you look at Lebanon and Hanover's ordinances, they are very clear. That would be a case of worst efforts. Do not cooperate. Do not make a phone call. Do not hold them. Do not permit the immigration authority to talk to the person who's being detained. Do not let the federal immigrations, even in your facility, as the case of Lebanon goes, do not detain the person once they're done with the state charge. So that would be totally going against, that would be worst efforts. Do not cooperate at all. Again, all we're asking for is you have the person make the phone call, contact the federal government and see if this is a bad actor that they want to detain, because we haven't weeded them out at the border.
Representative Newman.
Yeah, I just have a question. You talked about they just happen to become aware of this person is not a citizen in whatever the instance is. How does that happen? Does that mean they're going to be asking for citizenship, or how do if they stop somebody for speeding or whatever the crime happens to be?
So
how do they tell that they're not a citizen and they should make the phone call?
So usually, there's a ICE agent who's cooperated. He came in last year. He couldn't come in this year, and he testified that most of the time people, they're probably scared. I'm always scared when I get pulled over by the police. They tend to tell them that, here I am. Maybe they find out at the jail. The ICE agent from Chester, New Hampshire said usually they tell their status right away. They said, I don't have a driver's license. I'm not here legally. And usually it's forthcoming. So they're not interrogating these people. It's either come out in communications. They've told the police when they're at the jail. They ran the name. They gave their right name, and it came up. It ran in the ICE or the Homeland Security stuff. So it has come to their attention that the people are illegal. I guess you could lie and say you're someone else, and you might get away with it. But once the police know, we'd like them to communicate that to the federal government.
Thank you.
Representative Harry Gathright.
Thank you, Mr. Chair. In New Hampshire, for the most part, we truly believe in local control, not necessarily state dictate what the city or town is doing. So obviously, there's been an issue from what you're saying with Lebanon. Have you had conversation with their folks in their, whether it's their chamber or wherever it might be?
I've talked, there's one of the senators represents Lebanon. We've had a lot of communication, myself and her. And then you're saying that the problem is, so we had in Rye where we had the mass murderer working on a painting crew, eating lunch with everyone, going out to restaurants there, driving through my towns on the way home to Merrimack. If you have individual towns doing their own thing, you're putting the other towns at risk. So if Rye is going to allow a mass murderer there and not look for them, my bordering towns, I have 3 or 4 towns that border that town, you're putting all my citizens at risk.
Thank you, Senator. There being no further questions. Thank you for your
Thank you.
participation.
Thank you all.
So
Have a good day.
we're going to move on to the witness testimony now. We have a significant number of witnesses that are going to testify today. So I would ask that you please, if you are turning in written testimony, try not to read us what you've already going to hand in. And we're going to limit testimony to 3 minutes. So try to keep your points succinct and don't repeat what other people have said, so we can keep this down. Also, we will be working on this bill next Tuesday. I'm going to hold a full committee work session. So if you plan to come up and testify about how much you don't like the language, it might be different language by next Tuesday. So I would caution not to be too attached to what is written right now. And with that, I will call the first witness, and that is Representative Susan Ilberger. Did I say it right? Now you know who she is.
Thank you, Mr. Chairman. For the record, I'm Susan Elberger. I represent Nashua, Ward 1, Hillsborough District 5. I was born and raised in Manhattan, which was a gate city, and I now represent the gate city here in New Hampshire. All 4 of my grandparents were immigrants. I'm a second-generation American. All of us in this room, as far as I can tell, are not native-born or don't come from families that were native families. All of us are immigrants here, some by choice, some not. When I was in my freshman year in college, I was assigned a roommate who was a nice girl from a tiny town and had never met a Jew before in her life. And as we were getting acquainted, I was learning more about Catholicism. She was learning more about me as a Jew, as a New Yorker. And at one point I said, after I'd quizzed her about her background, I said, "Do you have any questions for me?" She thought for a minute and she asked me, where were my horns? I had no idea what she was talking about. So I asked her, and she said, all Jews have horns, which was a surprise to me because I'd never met any Jews with horns and I knew an awful lot of them. Prejudice comes in a lot of ways. And whether we're asked about our horns or about our accents, we tend to demonize people that we see as other. And we do that with people whose languages are different, or colors are different. It doesn't work. This country is founded on immigrants. All of us came here. Our families came here. Immigration provides a thriving economy, a thriving sense of new ideas. We have no proof that immigrants are more likely to commit crimes. We can find statistics that support us or not, but we really don't have any information to that effect. Having grown up in New York, the Statue of Liberty was a big deal for me. The poem on it, The New Colossus, talks about that statue as the mother of exiles. That's what this country is. Most of us know the lines, your huddled masses yearning to breathe free, but the first line of the quotation in there says, "Keep ancient lands, your storied pomp. We want the ones here, the huddled masses who need what this country can provide. We need to provide a way to make it easier for them to be here, and asking our local police officers to help get rid of them is not the way to go about it. Thank you.
Chair calls Michael York.
Good morning. As you may be able to see, I'm a Marine. 100% disabled, Vietnam veteran. On my third deployment into the Southeast Asia, I was a participant in Frequent Wind, and for those who don't recall the history, that's the fall of Saigon. I then went to the Philippines, where I met my fiancée, a Filipino woman, and we were married. When I brought her back to this country, we did legal immigration. We filed. I had to sign an affidavit of support that she would never be a ward of the state, which I kept for 30 years. She was not. I supported her. I recently spoke to her. We're on friendly terms still. She lives in San Francisco. That immigration, immigrants there that are all legal, that she brought over family, are incensed that we are allowing illegal immigration into this country. So what we're talking today is not immigration, it's illegal immigration. It's in the code. If you don't have permission to come to this country, you are an illegal immigrant. I don't believe any taxpayer money in the state of New Hampshire should be used on illegal immigration. If you want to change the laws to make it easier for people to come, that's fine. But the one question was asked just recently by one of the representatives about crimes. How many crimes? Well, everyone that's illegal has already committed one crime under the U.S. Code. So they're already committed a crime. In the Cheshire County, the sheriff will not allow his deputies to cooperate with ICE unless they actually have a felony warrant. Now, as a former police officer, if you stop somebody, they have to identify themselves. If they don't have an ID card or a driver's license, then you detain them until you can decide or find out what their actual identity is. And if it means a call to ICE, that's what you do. To not enforce any law as a police officer is a violation of your oath to protect the public. We go to Massachusetts, and it was mentioned, the prior gentleman, that the governor has asked Mass residents if they have room to please take in immigrants. Do we want that in New Hampshire? I have 2 spare bedrooms because my wife and I keep our same house even though the children are gone. But I'm not going to put a house in it. I don't have the money. And right now in New York, illegals are given $1,400 under the SNAP program. The average American citizen family, $713. A veteran, okay, thank you.
The chair calls Martin Toe.
Members of the House, greeting. My name is Martin Toe. I am a community organizer, faith organizer at the Granite State Organizing Project. And when I'm not bringing your local pastors together to work on making New Hampshire a more beloved community, I am speaking and performing at schools and conferences. You might catch me at the Multicultural Festival, throwing it down, and which I was doing today at John John Stark Regional High School, of many of the places that I've performed and speak at. And today it was interesting because I actually got this shirt from the John Stark Regional High School, which it says "Everyone Belongs." The two things that we really focused on was being open-minded. Sometimes you grow up in a small. I grew up in Concord, and sometimes you grow up in a small town, and it's easy to feel like that there is not a bigger world outside of the place that you live in, and for someone like me to come to the school and being able to connect with the students and being able to really show them that we have to be open-minded because even the people who are in the same class with you, they're not the same. And now imagine there's someone who lives in California, or maybe lives in Mexico, or maybe lives in Liberia or Ivory Coast or Europe, comes to your front door, and how do you receive that person? How do you hear their story? How's your heart connecting with them? Which was the second thing that we talked on, was empathy. And empathy is the ability to put yourself in someone else's shoes, which was what we were doing at John Stark today, having these students be able to get out of the shells. Most of them are coming from different households. They have different beliefs. And I say, listen, it's okay. It's okay you have these different beliefs, but right now, I need your heart to be full of love. My heart is full of love, and this is where we can connect with each other. So I'm asking you today to vote no on this bill, because it doesn't allow you to have your heart full of love. It doesn't allow you to be open-minded to the person that's coming at your door and being able to listen to their story. So that's all today. Blessings. Thank you.
Thank you for your testimony. Before I call the next witness, I want to remind everyone, although we are keeping you to 3 minutes, if you would like to submit written testimony, you can submit it through our portal, email portal, and it will become part of the record. So with that, I'll call the next witness. I'm going to have to step out shortly because I have a medical appointment, but the vice chair is going to take over for the remainder of the hearing. And with that, I'm going to, the chair recognizes Eva Castillo. Got this. Just like I'm doing it.
Good afternoon, Chair and members of the committee. My name is Eva Castillo. I live in Manchester. I'm a citizen by choice. I'm here to speak in opposition of this bill. First of all, I heard a lot of misinformation here. We are not being invaded by anybody here in New Hampshire. We do not have the infrastructure to house people. People are not being given money to live in any city. This bill really doesn't do anything to keep us safe. I have worked for many, many years with different police departments and to build trust in the community. A community is safer when every person that lives in that community trusts the police. It is not true that the police does not collaborate with ICE. When people are committing a crime, they are turned over to ICE. The judges do not put charges on people just to spare them from ICE. You commit a crime, you pay the consequences with immigration and with whatever criminal punishment you get. Being a non-documented person here is not a crime. It is a civil violation. If you re-enter after being deported, that's when it becomes a crime. But our police departments all collaborate with ICE. The difference is that they're not going to be just calling ICE when they find somebody that ran through a red light or committed a traffic infraction and they find out that they do not have a driver's license. But other than that, every time ICE needs their collaboration, they're there for them. We have heard opposition from the largest cities in New Hampshire where most of the immigrants live. You heard opposition from the police departments there. We do not tell a captain of a plane how to fly the planes, how to handle the plane. You know, why do we have to tell police how to do their work? They know what's best for their communities. This bill does nothing to help New Hampshire. This bill is going to make us all less safe because when people fear the police, and I'm not, not only undocumented people fear the police. We come from places where our police departments are crooked, they're mean, they're the rapists, and they're the bad people. They're not an honorable profession for the most part, like in this country. So we come here and we grow with having that fear in the police, and that's what we have inside in our hard disk. So it takes a while to learn to trust and to learn that not what we had in our countries from police is not what happens here. Many places, the police are also the arm of the bad people. So this doesn't happen here. Our police departments have worked really hard to make sure that every citizen that lives in New Hampshire, every person, trusts them so they can protect all of us. So please do the right thing and just ITL this bill. Thank you.
Thank you, Ms. Costello. No questions? Who do we got? Honorable Jim McConnell.
Thank you, Madam Chair, members of the committee. My name is Jim McConnell. You have, I hope, received my testimony. I will not burden you with reading the testimony, but I do want to call your attention to the back of the testimony, which reproduces Title 8 U.S. Code 1252C, authorizing state and local law enforcement officials to arrest and detain certain illegal immigrants. In particular, I want to call attention to authorizing state and local law enforcement officials to arrest and detain certain illegal aliens. State and local law enforcement officials are authorized to arrest and detain an individual who, number one, is an alien illegally present in the United States, and number two, has previously been convicted of a felony. Armed robbery, rape. Think about felonies in the United States and deported or left the United States after such conviction. So the bottom line is that barring our police and other law enforcement agencies from participating in the effort to help ICE rid the country and our cities in this state of those who've convicted felonies should be everybody's first choice. I don't really see any reason why this is controversial in the slightest. Unless you want your communities to welcome convicted felons, this should be a no-brainer. And I'm certainly hoping that you will OTP Senate Bill 563. I'm happy to answer any questions.
Thank you for your testimony. Are there any questions? Right. Thank you very much.
Thank you.
Elliot Berry.
Chairman, I'm here to speak to the amendment. I have nothing to add to the testimony of the opponent.
Okay. Sir, are you speaking to the non-germane amendment that was? Okay, just so you know, I don't want you to have, you're welcome to stay as long as you like. But when we open that, I am going to have to recess that until a week from today. The prime sponsor had to leave for a last minute medical appointment, just so you know. You're welcome. Maggie Fogarty.
Good afternoon, Madam Chair, members of the committee. My name is Maggie Fogarty. I'm the New Hampshire Program Director for the American Friends Service Committee. 106 years old, Quaker-founded organization working for human rights around the world. And we have written testimony, which I'll submit. It's quite lengthy, but I just want to lift up 2 or 3 key messages within the 2 minutes that I requested. So I'm here today on behalf of the New Hampshire Immigrant Rights Network, It's a statewide network of more than 200 individuals and organizations, nonprofits, immigrant support organizations, refugee resettlement, advocates, and attorneys, working together to improve the lives of immigrants in New Hampshire and to ensure their just treatment. And as a coalition, we are adamantly opposed to SB 563. We urge you to find it ITL. We urge you to unanimously find it ITL. Our key points are that there simply are no sanctuary cities in New Hampshire. This is, we believe, an intentional misnomer meant to generate alarm about a non-existent problem. New Hampshire has a full complement of federal law enforcement officers, including immigration enforcement, who regularly interact with state and local law enforcement, and they have an established relationship that is working for them, which is why you have heard from law enforcement leaders from the state's largest cities to say that this bill, they did not ask for it, they do not need it, and they do not want it. And that is why they describe this bill as unnecessary and ill-advised. The language that's being used to describe the need for this bill to address a situation of undocumented immigration in New Hampshire is not only toxic, it comes from a long tradition in this country of pitting groups of people against each other, blaming the other for all manner of problems, whether it's housing or employment or public health, and it's careless with regard to definitions. The word undocumented is applied to many groups of people who have permission to be here. They might have an application in process. They might be exercising their legal right to seek asylum in the United States. They might have one of the temporary permissions that exist in terms of deferred action for childhood arrivals or temporary protected status. So the language in support of this bill not only is intended to generate fear, but it's inaccurate and imprecise. This bill, the people likely to suffer most from this bill are those U.S. citizens and immigrants who will be targeted as looking like an immigrant. And we know that that generates racial profiling and feeds racial bias. New Hampshire needs newcomers. They're an essential part of our community health and well-being, an essential part of our workforce and our economy. And regardless of an immigrant's status in the U.S., this bill sends a message: do not come. Do not bring your family members here. It is not a safe place. So there are others behind me who will talk about the legal and constitutional problems with this bill, but I wanted to leave you with our core message. Our letter has 5 pages of signatures, faith leaders, nonprofit leaders, and others expressing their opposition to this bill. I also have a packet of data that I think will be helpful to your understanding of the reality of immigrants and their presence in our state. I'm happy to address any questions you may have.
No questions. Thank you very much for your testimony.
Thank you.
Bob Dunn.
Good afternoon, Madam Chair and members of the committee. I'm Bob Dunn, the Director of Public Policy for the Roman Catholic Diocese of Manchester, and I'm here today on behalf of Bishop Peter Labashi to respectfully register our opposition to SB 563. When I became Assistant Commissioner of the Department of Safety back in 1992, one of the first things I learned, and nothing over the last 30 years has changed my mind on this, is that the Department of Safety and the New Hampshire Chiefs of Police Association have never been shy about coming before the legislature when they thought that there was some change that could be made to New Hampshire law that would best protect the public safety. And so I think that it's significant that while this bill has been brought forward as something to advance the public safety, it has not been proposed by the very people that we have tasked with protecting the public safety in New Hampshire. You've heard about the concerns of what will happen if a bill like this passes and people are not inclined to go and to report crimes. And that's something that is significant because if people don't report crimes, then it makes it more likely that criminals are going to be able to prey upon people that are already in a very vulnerable situation. And so as a result, we respectfully think that the question of how New Hampshire law enforcement authorities decide to use their discretion with respect to ICE detainers is something that the state should leave to the discretion of the people that are the experts in this, that we've tasked to decide what is the best way to advance the public safety. And with that, I'll close my testimony. Thank you.
Thank you very much. No questions? Thank you very much. I would just like to remind all of our guests here that are here today, while we have somebody that has their time to be heard, it is difficult for the committee to hear if there are side conversations going. So if you could please refrain from doing that, that would be very helpful to all of us. Thank you. Sherry Rendell?
Good afternoon. Thanks for allowing me the opportunity to testify in strong support of Senate Bill 563 on behalf of the Federation for American Immigration Reform. We are a nonprofit, nonpartisan organization that was founded in 1979. We have 3 million members and supporters and approximately 4,000 in New Hampshire. If enacted, SB 563 would prohibit jurisdictions from employing dangerous policies that provide a safe haven or sanctuary in which illegal aliens can work and live without fear of apprehension from immigration officials. I am going to narrow my testimony down to some key points. You all should have received my written testimony, which is more specific. Proponents of sanctuary policies argue that enacting anti-sanctuary legislation like SB 563 will result in public officials and law enforcement officers discriminating against minorities. However, this issue has been addressed in the bill itself. SB 563 prohibits discrimination, saying that a state or local government entity shall not consider an individual's race, color, religion, language, or national origin. Additionally, opponents of the bill will say that anti-sanctuary legislation requires New Hampshire to enforce immigration laws, which is the responsibility of the federal government. The truth is, this legislation only ensures that state and local officials cannot block or prohibit communication and cooperation with federal immigration officials. Moreover, there is no requirement in the bill for public officials or law enforcement to comply with detainers issued by immigration officials. It only says that cooperation cannot be prohibited. We've heard a lot about detainers. Detainers are simply requests made by law enforcement officers asking another law enforcement agency to hold an individual for up to 48 hours so that individual can be picked up by an officer or agency making the request. Therefore, New Hampshire officials are not arresting individuals on immigration matters. Detainer requests are not solely related to immigration. In fact, law enforcement officers are routinely asked by U.S. Marshals or other law enforcement agencies to detain individuals. Likewise, I want to touch on the committing crimes at a lower rate. The assumption that illegal aliens commit crimes at lower rates than American citizens is not true. We had a study in 2019 of data from the federal government's State Criminal Alien Assistance Program, SCAP, that found illegal aliens are more likely to be incarcerated in state prisons and county jails than U.S. citizens and legal immigrants. In fact, in this report, in the states examined, it found that illegal aliens are incarcerated up to 5.5 times as frequently as citizens and legal immigrants. Additionally, the report found that states with the highest incarceration rates of illegal aliens are also those that have the highest
Ma'am, if you
numerous. Sure.
Thank you, everybody. Please accept my apology for needing to take a recess. If you would please like to continue with your testimony.
Sure. Thank you so much for allowing me to testify. In fiscal year 2023, which ended in September, ICE arrested 170,590 illegal immigrants inside the country, almost 45% with criminal records. Criminal aliens had an average of 4 charges and convictions each, including more than 33,000 charges or convictions for assault, 7,500 for weapons offenses, 1,713 for homicide-related criminal offenses, and 1,615 for kidnapping. Removals also included 3,406 known or suspected gang members. Moreover, state and local cooperation with ICE does not reduce the number of non-citizens reporting crimes or coming forward with testimony being criminalized. Besides the fact that anonymous tips can be given, there are already a number of programs that allow state and local police to encourage victim and witness cooperation by granting lawful status to illegal aliens who aid in the prosecution of criminals. If illegal aliens provide helpful information to police, they may qualify for UTS or VAWA non-immigrant visas, which in turn would ultimately allow them to apply for permanent legal status in the United States. Sanctuary policies actually prevent illegal alien victims of crime from taking advantage of these programs. In addition, according to a recent report by the Center for Immigration Studies, the data from the Department of Justice National Crime Victimization Survey shows that immigrant victimizations are just as likely, and in some cases more likely, to be reported to police than crimes against the native born. ICE has just 20,000 employees, only half of who are dedicated to the apprehension and removal of illegal immigrants. The cooperation of state and local enforcement, who number about 900,000 strong, is a force multiplier, vital to ferreting out those among us who wish to cause us harm. If ICE is forced to go into communities rather than the secure environment of local jails, many who wish us harm will not be removed and others may be put at risk. SB 563 ensures this cooperation.
We actually let you go over a little bit because we had a
Thank you.
disruption, but
I'm happy
Thank
to
you.
take questions if need be.
Representative Bolden.
Thanks for taking my question. In your written testimony, you said that New Hampshire taxpayers spend $107.5 million annually on expenses resulting from illegal immigration. Do I understand correctly that the methodology for that study was just to overestimate the cost of existing in New Hampshire and then divide that by the guesstimated number of illegal or undocumented individuals in the state?
So the methodology was used by our research team. They looked at the number of illegal aliens plus their U.S. born children and figured out based on costs of education, costs of justice, costs of healthcare, et cetera, how much it would cost each year above the amount that they paid in their taxes. So we do recognize they pay taxes, and or a lot of them do. So that is the amount that it's costing beyond that.
Follow up.
Do I understand correctly that in this methodology, you assumed that all of these undocumented individuals are on Medicaid and consuming several other programs and receiving welfare?
We do not assume. It's based on numbers that we can find out. It is not an assumption. There is some guesswork as to the numbers, but yeah, as far as the number of illegal aliens in the state, because there are not accurate records as to that, but it's based on population and census reports.
Representative Muse.
Can you tell me a little bit more about your organization and specifically why the Southern Poverty Law Center has actually identified you as a hate group?
Representative Muse, that please disregard. That is not okay.
Why isn't that okay?
Representative Muse, that is not an acceptable question.
Why?
We will be in recess.
Unbelievable.
Thank you, Representative Muse.
all around. Can we talk about? Wait, like all the way. No, half the budget. Okay. Yeah, that's why. I don't think I would.
What being a couple is.
Welcome back. We will continue our public hearing for Senate Bill 563, and the committee recognizes Gals Bissonnette. Please correct me whenever you.
Thank you. Thank you, Madam Chair, members of the committee. My name is Gilles Bissonnette. I'm the legal director at the ACLU of New Hampshire. We respectfully oppose this bill and would recommend that it be deemed inexpedient to legislate. And I think this is, I know I have very limited time, and I know we've been here for a while, and I'll try to make my points very brief, but I think this is really kind of a rare moment where you have groups like the ACLU, New Hampshire Liberty Alliance, Municipal Association, and many in law enforcement all opposing this bill for many reasons. And I think that is kind of an overall sign that this bill may be problematic in various ways. And I'm just going to share with you a few reasons why we think this bill is problematic. First, I do want to say that I know that there's been some data about undocumented individuals in crime. There is kind of a running dispute with respect to that data, and I'll make sure that I provide that in an email to the committee, so I don't spend a lot of time today talking about that. But I do want to just start at the outset. I know that there was some testimony that this is, a voluntary, bill. Municipalities, comply with detainers. They can elect to not comply with detainers. I just don't think that's true when you look at this bill and the intent behind it. I mean, this is a mandate that local police do the federal government's bidding with respect to federal immigration enforcement, and it does so without any training, funds for training, without funds for compliance, and of course without funds for any litigation costs that may emanate from this bill. And not only does it require compliance with detainers, it goes even further, right, to state that, quote, a law enforcement agency shall use best efforts to support the enforcement of federal immigration law. Now, I know that there was some testimony, hey, listen, we're just trying to make sure that local police make calls, but best efforts means best efforts. It is incredibly broad. It is not defined. And I think plausibly it could mean a whole host of things, not just a call, but having to hold people for ICE at ICE's request when a local police department may not have the resources, capacity, or ability to do it, or funding to do it, particularly in smaller communities. You can imagine how that would be a significant burden. Best efforts could also plausibly mean, ICE wants to conduct an immigration checkpoint where they stop everyone and they want you to comply. They want your services. Well, under this bill, best efforts, I think a very strong reading of that statute is you need to go do that for federal immigration enforcement. May not be the intent, but I do think it is incredibly broad, that sentence, because there's a robust enforcement mechanism as well that accompanies this bill. And of course, it does mandate compliance with detainers, because if you voluntarily elect to say we're not going to, comply with detainers, that is a sanctuary policy, right? That is prohibited under the bill. And I think really at its core, what this undermines is the notion that really in New Hampshire, we don't require our local towns to do the bidding of the federal government. And in fact, with respect to the things that the federal government's supposed to do, we let them do it. And lastly, with detainers, I just want to be very clear, there's no due process baked in them. I articulate that in our testimony. And lastly, I just would really strongly encourage the committee to read the letter submitted by many of the leaders in law enforcement that have expressed serious and real concerns with this particular piece of legislation.
Thank you for your testimony. Are there any questions? Seeing none, thank you very much. Grace Kandeke.
Thank you, Madam Chair, for taking my testimony, and thank you to members of the committee for hearing all of us this afternoon. So I will also be brief. I will simply introduce myself first and say that my name is Grace Kandeke. Thank you so much for pronouncing my name correctly. My name is Grace Kandeke. I'm the program coordinator for the American Friends Service Committee. I am a longtime Granite Stater, lifelong Granite Stater, and I'm also an immigrant from the Democratic Republic of Congo. I came to the United States when I was 2 years old, and for the majority of the time that I have lived in the United States, I have been undocumented. And so I've had to sit in the audience and hear a lot of testimony about what quote unquote illegal immigrants can and cannot do, what we believe they take away from our communities. And I'm here to say that our role, our work together, both as advocates and as legislators, is to make New Hampshire a safe state that is welcoming and able, makes it possible for all who live here to be able to live here with support and to feel welcome here. And so as an undocumented immigrant, I was an undocumented immigrant when I was going to Webster School, Webster Elementary. I was an undocumented immigrant when I made the honor roll at Bishop Brady High School. I was an undocumented immigrant when my mother, who is a long-time nurse's assistant, worked in almost every single nursing home, both at the county level and the local level in Manchester, taking care of community members and family members, I'm sure possibly even taking care of even some of your loved ones. And so I think it is really important for us to consider what is the spirit of this bill? What does this bill actually do? Does it truly make our community, our state, a safer one? Does it truly solve the problem that the sponsors have stated is there to be solved? Or does it in fact send a clear message not only to immigrant community members, but to immigrant loved ones? Because immigrant communities are not a separate entity living apart from other residents and citizens of the state. We are part of your families. We are your colleagues. We are in your schools. We are in your grocery stores. We are part of the fabric of this community. And not only do we contribute billions of money and tax dollars to the state without being able to access any of the social safety nets that some people here have claimed that undocumented immigrants we cannot get on Medicare. We cannot receive welfare. We cannot do a lot of things, and yet we still continue to contribute to this great state. And so I have the immense privilege of now being a U.S. citizen, but I know that it is important. My work is to continue to raise the profile and raise the voices of communities that I come from, knowing that not so long ago I was in those communities. And we are not talking simply, we need to examine intent versus impact. And the intent and the impact of this bill is that it will make it that much more difficult, that much more scary, that much less welcoming in our state, not only for immigrants, but also for the people who love them, who work with them, and are part of their lives. And so I strongly urge the committee to really consider what kind of state are we trying to be. Let us not fall into fear. Let us not fall into the false rhetoric that pits us against each other, but to really examine that there are many ways that we can contribute to a safer New Hampshire, but this is not one of them. So thank you for taking my testimony. I'm happy to take questions.
Thank you very much for your testimony there. Representative Selleck.
Thank you so much, and thank you for taking my question. You said in your testimony that you were not eligible to receive services. Could you expand on that just a little bit more for us, please?
Yes, so absolutely. So I come from a single parent household. My mother was a single mother, my father having passed away when I was only 4 years old. And so she was a widow raising a child alone. And so not only was she a single parent, we were poor working class. She worked multiple jobs in nursing homes, and she was eligible for she would have been eligible for many different services, including Medicaid, Medicare, as well as WIC, all these care packages that we have available to low-income families with children. But because we were undocumented, we were not eligible for any of those services, and that fact continues today. So that we have even undocumented families now in 2024 would not be eligible for those services.
Follow up.
And was your mother, in your case, as you brought her up, paying taxes during that time?
Oh, absolutely. My mother worked for, like I said, for all different nursing homes in the state of New Hampshire. And she paid taxes every single year. And in fact, even when I was able to finally get some work, I worked as an art model. I know I'm very pretty. Worked as an art model. I worked at a Chinese restaurant, and I paid my taxes. And my first income tax that I filed was for $7,000 worth of income in 1 year. And I still pay taxes on that. So we have been paying taxes for decades, as many others have as well.
Representative Reed.
Thank you, Madam Chair. Thank you for taking my question. What is the obstacle or obstacles that prevent people from getting citizenship when they're here for a majority of their lives? It seems easier from my point of view to start the process so you get benefits that you contribute to. It just sounds very difficult to navigate the system the way it is. So can you shed some light on why it's hard for children brought here and go so long without citizenship? Thank you.
Yes, absolutely. Thank you for that question. So I know I will use my own case as an example. The reality is that our immigration system, many folks, I'm sure you've heard the phrase of speak to the fact of claiming that people need to get into line. You need to get in line. Don't cross over somebody else. But the reality is within the immigration system, there aren't a lot of pathways to be able to regularize your status. So for instance, in my case, I came to the United States on a visa. Technically legal, and then I fell out of status very shortly thereafter. And so for decades, there was no way for me to regularize my status. We had the opportunity to be granted asylum. Our case was particularly complicated. So it really, because it takes the burden of proof for asylum cases is on the petitioner, right? And so there isn't a lot of pathways. There's not a line to get into. And so that's why a lot of people who are like me, people who were on deferred action for childhood arrivals, children who came as children and became undocumented, there simply isn't a path forward. And so even for myself, my own story, the only way that I was able to regularize is through my marriage to my spouse, who I've been with for 15 years. But if that wasn't the case, if we had broken up, if we had decided not to get married, I would still be sitting here with deferred action for childhood arrivals. I would not be a documented resident.
Representative Bolden. Thanks for taking my question. Earlier, we heard about this number, 107 million is what it costs New Hampshire to have undocumented immigrants. My understanding is the study includes costs attributed to immigrants being on Medicaid. Can you speak to that?
So I unfortunately cannot. I don't quite have the numbers. I will just say that it costs the state money to have anybody living here. But I think what's also important to look at in terms of that kind of data is how much money do people contribute to the state, and whether in tax dollars, locally, or at the state level as well.
Thank you very much.
Thank you.
Mr. Holt, and if there is anybody here that wishes to testify that has not turned in a pink card, now is your time to do so, because this is our last guest on this Senate bill. 3 minutes.
Whenever
Sorry,
you're
we
ready,
have another
Mr. Holt.
person coming up. Hi, thank you for hearing me. My name's David Holt. I'm here to oppose SB 563, which is going to make the state unsafe for me and everyone here. I'm opposed to this, as are police across the state. I'm a second generation immigrant. My grandmother came here actually before there was any immigration legislation, as so many did, unless you are an indigenous person or a person who is descended from people that were brought here against their will. I guess I would like to ask, have you been out in our community lately? You can't walk 5 feet without seeing a help wanted sign. There is a labor shortage and we need immigrants to work, and many do jobs that no one else will do. Without immigrations, New Hampshire's populations would have shrunk last year. Along the same line, there's a housing shortage. And who are the people that work in construction? It's mostly immigrants. And the problem is with all of the anti-immigrant actions that are taking place, if we decrease the number, we're going to have even less housing constructed. So we're biting off our nose to spite our face. With the limited resources that developers have these days, they're of course choosing to build the more profitable luxury apartments, which are not helping out any of our citizens. We should all be aware that the federal government is responsible for immigration. Specifically, this is planned out so that state and local police can build positive relationships with everyone in our community. This bill will foster a lack of trust among all immigrants and BIPOC and everyone else in our community, fostering racism, and it will make us or our state less safe. One of the things that has come up previously was about taxes. Immigrants actually do pay taxes. They contribute to our economy. But even when they are naturalized, which usually takes years and years, there is then a 5-year waiting period or gap before they're able to accept or receive any benefits. There are refugees, which are a very small portion of immigrants, that actually do receive subsistence, but it is laughable. And then I'd also like to state, if you all have a cell phone, if you could just Google FAIR, you'll find that the Southern Poverty Law Center has named that to be a hate group. It's easy to find for anyone. Thank you.
Any questions? No? Okay. Thank you very much. Reverend Davis?
Yes, thank you. I thought a card had been submitted, so I'm glad you mentioned that. Thank you. Reverend John Gregory Davis, with my partner Susan, I co-pastor the Congregational Church in Meriden, New Hampshire, where we've been for the past 30 years. And we are one of 3 sanctuary churches in New Hampshire, and we live just below Lebanon, Hanover, those pernicious communities that have declared themselves welcoming and therefore must be hotbeds of dangerous potential terrorists. I would just suggest that we've had just the opposite experience. And I want to begin first by expressing some dismay that we've allowed the language of illegal to be used too many times today. You know, a young woman from China in our congregation once asked me, how can any human being be illegal? I'll leave it to you to answer that. I said to her, no human being is illegal. There may be people who are undocumented, but they are not illegal. So I hope henceforth we will not use that language. I want to just submit that this legislation is based upon fear. And imagines terrible people, the next 9/11 terrorists. I mean, we could argue that in my mostly white community, where people like me reside, we're harboring the next Timothy McVeigh. It's ridiculous in terms of saying that just because someone looks like a terrorist, that everyone else who looks like them is going to be terrorists. We had the privilege of hosting a Brazilian family in our home for 8 months. It was a tremendous benefit to our family. I wish I could snap my fingers for a moment and make every undocumented immigrant disappear from this nation. I suspect I'd hear a great howl and outcry. What's happening? Where are all the services that we've taken for granted? I didn't know until we had Brazilians living with us that, for example, many Brazilians clean the buildings overnight that many of us expect to be clean when we go into. The opportunity, our kids play with their kids, they're our neighbors, their language, their culture enriches our lives as well. And I'm sure you've heard from a number of people from our church already saying that we would urge you to urge your opposition to this bill. And I want to just conclude with the last line of my testimony, which I'll submit to you, just saying that SB 563 is unnecessary and harmful and does not reflect the New Hampshire values of hospitality and community safety. Our immigrant friends and neighbors throughout our state, and we, their friends and neighbors, are counting on you to oppose this misguided bill. Thank you.
Representative Reed?
Thank you. Thank you for taking my question. Does your church receive any funds from the federal or state government for taking in any of our immigrant population?
Wow, that would be so nice. No, somehow that question's never come up about offering us funds. No, it's been quite the opposite, actually. Or at least we've needed to rely on our own resources. And fortunately, we've had an outpouring of resources to help us with that.
Thank you very much. Evelyn Lewis?
Good afternoon, everyone.
Good afternoon.
The name is Avalon Lewis. I want to thank you for having me speak here today. This is my first time, so it's a little bit nerve-wracking, a little bit nervous. I hope that you would bear with me. Currently, I reside in Nashua at 22 King Street, but I came to this country. I too am an immigrant. I came to this country in 1972 as a visitor. I then turned around and applied, well, my family applied for permanent residency for me. And although all of my siblings made it, I did not. I was not accepted simply because I had aged out. I had to start the whole process all over on my own to become a legal resident. Because I aged out, the immigration, let's call it just immigration, put me in a status of illegal immigrant. And I was told, in so many words, that if I kept my nose clean, not cause any problems, that I wouldn't have an issue, and that would allow me to continue my preparations for legal residency. And I was successful at that. Now, before I gained legal residency, I had no access to any of the privilege of a legal or of a citizen of the United States. I accepted that because I was an illegal immigrant, an illegal alien. I gained my residency, my permanent residency, but I was still limited to what I could access as far as federal programs and stuff like that. I too accepted that because I wasn't a citizen. I became a citizen, and it allowed me or afforded me a whole lot of other benefits that this country provides. And I like that. I cannot understand why people are making excuses for becoming a legal resident of the country. In any country you go to, I travel a lot right now, I travel abroad. In any country you go to, you have to register being in that country because they want to know who's coming in, who's staying, how long they're staying for. That is their law. That is the law of the United States. I have no issue with that.
Mr. Lewis, if you could just finish up that sentence. I'm sorry, but your 3 minutes is up.
Oh, okay. Well, I am in favor of this bill. I definitely am. If you are in the country, you should be legal. That's all I have to say. Thank you.
Thank you very much.
Any questions?
Representative Sitek?
Irrespective of your position, your first time was great.
I'm sorry?
It's not a question.
Your first time testifying, you did a very nice job. Thank you.
Oh, thank you very much. I appreciate that. Now gives me greater confidence for the next one.
We hope that you'll come back and join us again.
Thank you.
Is there anybody else here that has not turned in a pink card that wishes to testify? Seeing none, we will close the hearing for Senate Bill 563. And we will open the public hearing for Senate Bill 578 and recognize the prime sponsor as soon as I can find the bill to find out who that is. Okay. If you could just give us 1 second, let people clear out. Senator Prentice, whenever you're ready.
Thank you. Good afternoon, Chair and members of House Criminal Justice and Public Safety. For the record, my name is Sue Prentice. I'm a state senator from District 5, covering large parts of Grafton, a part of Sullivan County, and one community in Merrimack County, the beautiful town of New London. I appreciate the opportunity to introduce to you today Senate Bill 578. This bill provides that individuals who are indigent and charged with a crime do not have to pay the cost of their own electronic monitoring equipment if their case terminates without a conviction for any offense. And I want you to hold into your mind plea deals until we get to the end of this bill, because I have a suggestion to make, kind of on the fly, but I would appreciate your indulgence. This bill actually the idea for this bill came from work that you had already been doing in the area of bail reform, and is tailored to meet, fit in with a particular part of, the pretrial monitoring. To pull that out, I've actually had talked to Representative Roy about the work on this in the Senate so that we could find a way to bring this about either through this one tailored bill or through what I ultimately hope is a broader package. So the idea started here, and we were listening. I had been listening to some of the experiences from different counties, from folks who had been through trials or incarcerated in different counties. And as you may remember, there was an individual from Stratford County Corrections that said something that really struck me, and it also stuck with me, which was that the cost was $5 a day for an electronic monitoring if it was a requirement for them to wear one, which if they couldn't pay that, physical labor was required. I'm not necessarily I understand that there need to be conditions in place, but I'm not sure that this is the best way to get at it, considering that this could cost up to $150 or more. And for some who are struggling already to pay rent, supporting their families, trying to hold down one or more jobs, I think that there's a trade-off here where we have to think about, do we want them to be in a county jail, what it costs per day to be in a county jail, versus what we may excuse for that period of time, and especially and in particularly if their case ends terminates without any type of conviction. So I'm asking to think about what that trade-off might be. I would prefer to keep folks who it's again appropriate and who can't afford this out of prison with their families, working within their communities and staying connected up until a point where there's either a conviction or not. And this seems to be, in my experience, both serving locally as well as here, is that it's not our way to force the lower income members of our community to do things such as maybe be physical labor to pay for a device who've been charged with a crime and have not yet had a trial. Now, I know this is only one story, but I just, again, want you to think about this in the broader context. I wanted to make it clear, and I had already stated this, that I think I'm not suggesting that there should be nothing at all, but we should consider how to approach this rather than labor. There needs to be the pretrial electronic monitoring. I'm all in favor of that. It's how is that paid for, especially when they're innocent until proven guilty, and the way the bill is written, it sets it up so that determination, not of their status on the crime, but whether they qualify for this pretrial monitoring, electronic monitoring, is done up in front. And then if the case terminates without a conviction, they don't have to pay that back. I still contend, and we don't have all of the data, and I understand that the county will speak to some of the representative from the Counties Association will speak to some of this, but I still contend that would be potentially less than what it would cost, up to close to $300 a day, for them to be in a jail cell. So these bracelets, again, the electronic monitoring devices, they serve an important purpose for somebody, again, who's been determined that they've not committed a serious crime, that they are, going to go to trial for. They're not a threat or a danger to the community. We want to put them back into the community again, be with their families, work their jobs, support their families and be connected. This is a way to achieve that. But again, not everyone can afford that $5 a day. And, I have to say, my own, it's like my own Catholic guilt moment is that when I go and I buy my daily cup of coffee, I spend just about that. And to think that somebody else doesn't have that money to cover a cost like this is, I'm starting to think twice about that. And my mother has reminded me. So again, not being found guilty of a crime, done at the beginning of the process, using the indigent defense language that has been, there's some precedent on this as well in statute and as well as in the court system, using that language so that we have a place to go with this. So I'm proposing again that we set up the system where if somebody at pretrial, it's required for them to have an electronic monitoring device. If we use the indigent defense language to narrow that down to that they qualify for this, that we're not charging them per day if they are cleared when their case terminates. So plea deals. I hear there's a concern that's come up recently about plea deals not being covered and how many people plea out, and that this could again become a cost for the counties. This is very new to me today. I wasn't aware of it. So I would ask for the possibility to work further with the counties to see if we can amend this, because we've actually amended this already once, working with county government to try to make this work. I'd like the opportunity to do that again if you should so see fit. So thank you very much for your time. And I know you have a busy afternoon. I'll do my best to answer any questions you may have.
Thank you very much. Representative Mannion, did you have a question? Representative Muse?
Hi. I do have a question about your bill versus the bail bill, which is HB 318 that just went over to the Senate. There are provisions for the state to pay for monitoring and pretrial services for people who are indigent in that bill, but I believe it's only in the cases in the case of 318, it's only for protective monitoring and misdemeanor domestic violence cases where people are released. So your bill would actually apply beyond that.
Wider.
For any reason, a person may actually be asked to be monitored, right?
Correct. And again, not deemed by the judge a threat to public safety. It is not a higher charge.
Quick follow-up.
Follow-up.
And I just, have you had a chance to review the language of 318? And if you have, what did you think? Are there conflicts? Are there things in there that need to be incorporated that are part of your bill?
So thank you, Representative Muse, for not just the first question, but the second one. So I have, and I've also spoken with Representative Roy about this in trying to, I think there's a lot of intentionality between the two of them. Mine is a little broader. The House bill is a little narrower, but I think they could get us close to the same place. So what I'd like is for one or the other to land. And I'm partial to working on the bail reform, but if things don't settle with that in the Senate, this would give us at least one piece to work with. So thank you.
Thank you.
This is your sign to please pass our bail bills.
I hear you.
I don't see any further questions. Thank you for your testimony.
Oh, you're welcome, and thank you.
Kate Horrigan. Come on up.
Good afternoon, representatives, Madam Vice Chair. I'm Erin Creed. I'm the General Counsel for the Judicial Branch, and I'm appearing as hype woman for Kate Horrigan. But
Kate Horrigan from the New Hampshire Association of Counties.
Thank you so much. I know we've had an opportunity to speak in the past about similar concepts while you were working on your bail package, and I've appreciated so much the ability to work with so many of you. We did have some follow-on conversations in the Finance Committee. Rep. Muse, I know you're part of those as well. For those who are coming from other states or from the federal system, they may believe that there's a robust pretrial division in the New Hampshire Judicial Branch. That doesn't happen to be the case in New Hampshire. We don't administer any electronic monitoring, and we do not have any staff that works in this area. Electronic monitoring in the state of New Hampshire is administered by the counties. So we worked with Rep. Roy and others to change HB 318 to sort of voluntarily transmit some of those responsibilities from the courts over to the counties, where the expertise and the knowledge is. I think the Senate helpfully improved this bill by adding the counties in. My suggestion would be to take the courts out, and then you will have completed the transition over to the party with the most knowledge and responsibility in the area. We do not have a policy position, as we generally do not on the underlying bill. However, I'm happy to give you any technical feedback that you might find useful. And otherwise, I transmit you to the counties for more expertise on electronic monitoring.
Thank you, Erin. Thank you, members of the committee. So just to start up front, we are happy to work with Senator Prentice on any language that she would like to amend or see. And I'll echo Erin's comments that we did a lot of work in Senate Finance around House Bill 318, and we believe that is the method that goes forward. Just a couple of concerns the counties wanted to flag for everyone. So we do believe that collecting fees after someone has been convicted is going to be an administrative burden on someone. Right now, it's done by weekly or bi-weekly, depending upon the county, because as you all remember from your study this last fall, each county's program is very, very different. To address the Stratford call, so no one is forced to do labor. Stratford County works with each person who is on electronic monitoring to find something that they are willing to do if they are unable to pay back. So that could be, yes, they do have the option to do wood stacking, because Stratford County does cut and sell wood, and that's a profit to the county. You can also work with Special Olympics, who happens to be their charity for this year, in doing office things, stuffing envelopes, things like that. Sometimes, you know, somebody wants to get outside and wash the sheriff's cruisers. Great. We will work with you to find something that you want to do. But I just want to be clear, no one is forced to do hard labor to get on electronic monitoring. And I'll leave it at that. You guys can read our letter, but just the concern, most people don't get a conviction. Most people end up with a plea deal. That's not a conviction the way this bill is written. And the fact that we have to wait until they're convicted, we hold very few convicted inmates. Most of them are going to the state prison, where we may or may not ever see them again. So, but happy to take any questions that the committee has.
Did you have a question? Representative No?
Thank you, Madam Chair. And I just wanted to clarify, I'm going through, and what you had said was to remove the court. And so I'm going through here, I got in line 6, shall be paid for by the New Hampshire court in which the defendant is charged, that court is providing and requiring electronic monitoring. So what you're saying is that it's not the case, for one thing. So it doesn't necessarily apply. I just want to kind of be clear about things that might need to be amended in this that would make it appropriate. So I'm kind of looking for different references. But the one thing that I wanted to discuss specifically is, as I'm going through and finding those specific things, there's the court shall develop uniform criteria to evaluate and determine. So that's kind of something that is the responsibility of the court. It's not in a list, as most of these are, as the court, the county, or agency. This is something that is specifically assigning that to the court. So what would we be replacing that with?
Great question, and I will turn it over to Kate in just one moment. But you had very similar language in your bail package, and I do believe that the counties asked for that to be changed, so that it would be the counties making that determination in that instance as well. Certainly it's your policy judgment if you want the courts to be more involved, but I can turn it over to Kate to tell you a little bit more about how the counties would administer that.
Sure. So I'll just point out that just because you're indigent in one county doesn't necessarily mean you're indigent in another county. And also, because you're indigent for a lawyer doesn't mean you can't afford electronic monitoring. And since each program is different in terms of what they ask to reimburse, so some counties just ask for the reimbursement of the bracelets. Some counties include the cost of the bracelet, the software, the hardware, and the personnel to manage that. So giving the counties as much flexibility as possible to administer these programs and incorporate each unique feature for those programs would be greatly helpful.
Thank you.
No more else? No? All right. Thank you very much. Is there anybody else here wishing to testify on Senate Bill 578 that is not turned in a pink card? Seeing none, I will close the public hearing for Senate Bill 578. And let me see. Does the committee members need a few minute recess before we open up the next hearing? Are we good? We're good? Okay. All right. So, I will open the public hearing for Senate Bill 591 and recognize the prime sponsor to introduce the legislation. We could probably tell David they couldn't go home. President Bradley. I didn't hear you. Would you like me to hold on one second. I think he might be out in the hallway. Wow, this Representative Sullivan, did you want to take a minute and introduce this is a lot of bill not to be here.
Good afternoon, everyone. For the record, I am Lauren Selig, and I represent Durham, which is Stratford District 10. And I am introducing this bill as apparently our sponsors are not able to be here at the moment. This is Bill 591 FNA, an act modifying definitions, claim procedures, and funding related to the Youth Development Center Settlement Fund and Claims Administration. The bill significantly modifies definitions, claims procedures, and funding related to the Youth Development Center's Settlement Fund and Claims Administration. And I cannot take questions because I know nothing about this bill other than what's on the paper, but I know that we have some outstanding experts here to speak on it.
By any chance, do we have anybody with us that is a co-sponsor? I'm looking quickly and I don't. What's that? Oh, okay. We'll give him that 1 minute. Yeah. We'll go ahead and be in recess just for a few minutes if anybody needs to step out real quick. Representative Selig introduced the bill, but clearly she just read the title for us. So I will reopen the public hearing for Senate Bill 591. And Senator Bradley. This is Representative Roy's Thor. I just really make fun of it, but unfortunately I needed it today. So
any rate. Thank you very much. Apologize for being across the street. We're all trying to do too much with too little time. So I would like to introduce 4 committee members, a letter from the attorneys that are involved in this. So for the record, Jeb Bradley, Senate District 3, appreciate the opportunity to testify on behalf of Senate Bill 591. Want to thank all the bipartisan co-sponsors that are on this bill and talk about the importance of the bill. I think anybody that's been following the recent trial knows exactly how important this bill is. My good friend and colleague, Karen Umberger, filed the first legislation, House Bill 1677, as I recall, in 2022, that started the settlement process. As you will hear from the Attorney General, I think, later this afternoon. The settlement process is proceeding, but there are some significant changes that should be made to improve that process that will better enable the clients of the attorneys that are here today from Nixon Peabody and Riley Associates to be able to recommend that the people they represent enter the settlement process as opposed to the litigation process. If there are some 1,000 cases, maybe more, if they were not to settle on a large number of those, it would clog our courts up for years with unknown outcomes in the litigation process. Unknown outcomes could mean a huge expenditure for the state that is not only not able to be determined, but not able to be managed. Therefore, both sides have come together as they did a couple of years ago to negotiate the first settlement process, and they've come back with, I think, what is a more comprehensive approach that will better enable, as they say in this letter, the improved process to recommending the improved process to the vast majority of our clients as appropriate based on the facts and circumstances of each case. There will probably be some cases, as there is the case currently right now, that will go through the court system, but if we can pass this bill as is, I think it will better enable us to manage this process. So if I can touch on the high points of the bill, there is a new definition on the first page of the bill on line 15, egregious sexual abuse. So egregious sexual abuse will be a heightened term that will be eligible for a heightened settlement. That's the first big change. On line 25, physical abuse would change to other abuse with some of the criteria outlined on lines 27, 28, and 29, unlawful restraint, strip search, emotional distress. On page 2, there is a change where you would have a cause of action for an invasion of privacy. That's lines 5 and 6. There's a definition of unlawful strip search. And again, I'm just hitting the highlights because this is a long bill and you can ask questions. So on page 3, a very important criteria is that the payout would be payable under terms and conditions as determined by the administrator, accepted by the claimant, subject to the limitations of the statute. So that better defines the role of the administrator and how payouts would happen. The bill on line 18 on page 3 allows for assistant administrators. I think Justice Broderick is doing a very good job under trying circumstances, but with what I think everybody hopes for, acceleration of the process of more settlement cases, there will be a need for more folks to work with the Justice Broderick. On page 4, on line 28, number 4, aggravating and mitigating factors was already in the statute, but there is new language added about multiple forms of sexual and other abuse. On page 5, as I said before, egregious sexual abuse would be eligible for, instead of a maximum $1.5 million settlement, it would be eligible up to $2.5 million for egregious sexual abuse, and other abuse would increase from $150,000 to 250,000. These new numbers, while yes, higher, will enable more settlements. More settlements equals more predictability for the state over a longer term and ability for the state of New Hampshire to be able to manage its budget and meet the need for closure and compensation for these victims that were the subject of some pretty significant and horrific abuse under the state's care. There, on page 6, on line 11, the date for filing for settlements is extended to June 30th of 2025. It's currently the end of this year. That will allow a little bit more time, given that we are making changes. Then there are numerous places where other abuse, as opposed to physical abuse, comes in. For instance, at the bottom of that page, line 33. Also at the top of page 7, but you see that numerous times. So I'm going to flip to page 9, actually 10. New language has been added on page 10, excuse me, line 18 and line 17 about investigations being conducted in a trauma-informed, respectful, and dignified manner. This is obviously part of the settlement to make sure that victims are treated appropriately, because that's what they are. They are victims. Again, hitting the highlights on page 11, the Attorney General designee and the claimant or claimants may also engage in discussions to resolve claims. This makes sense. So at the bottom of page 12 is a provision that allows a claim to be paid in annual installments, which is very important in the managing of our budget situation. We are projecting in this bill, and that would mean, please turn to page 13, that approximately $75 million would need to be appropriated in any given fiscal year. So the Attorney General can probably give more up-to-date numbers, but my understanding is there are well over 100 cases that have settled at about $450,000 to $500,000 on average per claim. So I think you can see the need for managing the budget process for the state while at the same time protecting the rights of the victims and the responsibility of the state to make compensation. On line 20, the administrator will have discretion within available appropriations to determine whether a claim should be paid as a lump sum or in increments over a several year period. Again, this is a budget management tool. There on line 26, in order to make that fair for the victim, a 5% interest will go along with the extended payments as opposed to a lump sum payment. That was a agreed upon percentage between the Attorney General's office and the attorneys from Nixon Peabody. I think that's fair, given that there could be extended settlements. So I think I skipped over a little bit. The $75 million, that's what's anticipated. The administrator could not authorize more than $75 million in any fiscal year. but the administrator is allowed to ask the fiscal committee to exceed that amount should it be necessary. On page 14, this again talks about what happens if the administrator believes there's a shortfall in the settlement fund, to, after consultation with the Attorney General, can make a request of an additional appropriation. On lines 22 and 20 through 24, the state treasurer is authorized, with the approval of the fiscal committee, to borrow if that becomes necessary. Hopefully it never becomes necessary, because we're trying to design a process that manages the appropriations. And then the last critical piece, and I apologize, I was using the bill as introduced. I'll go to the Senate passed version. The only amendment that the Senate made to the bill was on page 19, adding the $60 million appropriation on line 19. That was at the recommendation of the Attorney General's office. This is a large amount of money on top of the $100 million that's already been segregated from the rainy day fund for purposes of trying to resolve this. So I apologize for taking a long amount of time. I just want to walk through the highlights and again stress the importance of unless there's agreement between the Attorney General's office and the attorneys, that this is a package and it holds together because there was cooperation, and quite frankly, both sides should be congratulated for the cooperation that they've exhibited. So please, no amendments unless both sides have agreed to an amendment. That doesn't mean there may not be good ideas, but please, this is a settlement piece of legislation. And again, this allows us to do right by victims, but at the same time protect the longer term financial health of the state. That's a very difficult task for all of us. And I think that's why the Senate voted for this 24-0, because I think people on both sides of the aisle have seen this is a way to resolve these egregious problems of the past, doing right by victims, but protecting the state. So happy to answer any questions, and thank you, Madam Chair.
Representative Muse.
I did have one question, and forgive my ignorance on this, but are settlements, are not settlements, but are judgments that are independent of the settlement process paid out of the settlement fund, or do they come from another financial
That probably
source?
the Attorney General could better answer than me, but my understanding is the Attorney General already has the authority to make settlement cases up to, I believe it's $475,000, if an Attorney General deems that is in the best interest of the state. And it would be outside of this process.
Thank you.
Representative Harry Gathright.
Thank you, Madam Chair. On page 19, you mentioned, can you tell me again what was on page 19? Because what I have only goes up to, I believe, 16. So I just wanted to capture what you said. I think that was in the original, maybe.
I think I said 19, and I apologize. I should have said 15.
Oh.
So the amendment that the Senate adopted was on page 15, line 19, the $60 million appropriation on top of the $100 million that the previous legislature put into a dedicated fund for this purpose.
Thank you.
Mm-hmm.
Seeing no further questions, thank you, Senator.
Thank you.
Esquire Cantor.
Good afternoon, Madam Chair, members of the committee. My name is Michal Cantor. I'm counsel with the law firm Nixon Peabody. I, along with my colleagues Dave Vincenzo, Mark Knights, Dan Dean, and Russ Riley of Riley and Associates, represent over 1,300 victims who suffered sexual, physical, and other kinds of abuse at YDC and other state facilities. My colleagues wish that they could be here today, although they are unable to attend because they're currently representing our client, David Meehan, in the first trial against the state for YDC abuse. I'm testifying today in favor and in support of this bill because it makes meaningful changes to the settlement fund that we believe will make the fund more attractive to our clients, the victims. I submitted written testimony today that I will briefly summarize. I lead the legal team at Nixon Peabody and Riley and Associates. That team helps, I lead the team, that helps clients submit claims into the settlement process and represent those clients through all stages of the settlement fund process. However, to date, a small percentage of our clients have actually submitted claims to the fund. And that's for a variety of reasons, including the fact that the caps are too low on compensation in the current form of the program, and also because the program only compensates victims for a limited scope of abuse. And by that, I mean strictly sexual abuse and physical abuse. It's also problematic that the current fund is cumbersome, time-consuming, and at times not victim-friendly. However, the bill before this committee addresses those issues, and I'd like to take a moment to thank the Attorney General's office for their cooperation in coming to these compromises that are reflected in the bill before the committee. Namely, those include increased caps, like you heard Senator Bradley refer to, caps on sexual abuse and caps on other abuse. Other abuse is a significant compromise in this bill. Whereas the current fund only compensates for sexual abuse and physical abuse, the improvements that are recommended in the bill would make it so that there's a category of sexual abuse and other abuse. And other abuse would encompass not only physical abuse, but other types of abuse, such as solitary confinement, unlawful restraint, and child endangerment. And so we support this bill for our clients because it makes it so that our clients feel validated, feel that their abuse is validated. I've heard from clients who are so encouraged at the prospect that they could receive compensation for the very lengthy solitary confinement that they endured at YDC and the other state facilities. I've spoken with victims of egregious sexual abuse that feel validated that there could now be a cap of $2.5 million for what they went through. And while not all of our clients are excited to talk about what happened to them, most of them are certainly eager to settle their claims as quickly as possible. And this bill provides the framework for a much more expeditious process, including because it permits the administrator to appoint assistant administrators, which would speed up the processing of individual claims. Overall, we support the changes in the bill. We encourage the committee to pass it. And as our letter to Senator Bradley indicated, if this bill is enacted, we anticipate recommending the fund to the vast majority of our clients as appropriate based on the facts and circumstances of each case. Thank you, and I'm happy to take any questions.
Thank you for your testimony. Seeing no questions, thank you very much.
Thank you.
Mr. Attorney General.
Thank you, Madam Chair. Members of the committee, good afternoon. Just for the record, John Formella, Attorney General. Whenever I speak about this topic, whether it's in front of the legislature or anywhere else, I always just like to start by acknowledging the difficulty of the topic and the difficulty of the material, and acknowledge what the victims that we're speaking about have been through. I think it's always important to keep in mind that, you know, we have a lot of people involved here, and each one has a different story, and it's important to remember that they're each individuals. And so while, you know, with a case like this that involves so many victims, we just try not to lose sight of that. Just take a moment to remind the committee as well that, you know, as Attorney General, for something like this, I play a really unique role because I have to oversee both the office's civil litigation function and the criminal investigation, the criminal prosecutions. So that is a, you know, it's something that has been discussed in the press. It's a concept that I admit can be difficult to grapple with. It is just part of the very unique role that we play at the Attorney General's office, and we take our responsibilities very seriously to try to separate those functions and to perform both of those functions in good faith and on behalf of the people of the state. But it will perhaps limit some of the questions I can answer. I'll take every question you have at the end of my remarks, but it may limit me and what I can answer and what I can say. But I just like to put that out there and remind members of the committee of that. As many of you will recall, we came to the legislature in 2022 to establish the YDC claims fund and settlement process. At the time, over 400 victims had come forward. So even in 2022, we already knew that this was a major undertaking, and we were dealing with a situation in which many people, we're dealing with a situation involving many people who suffered some terrible things, terrible abuse, physical and sexual abuse as children while in state custody. When we brought this to the legislature in 2022, we also made clear that we still didn't know the full scope of what we were dealing with, and we didn't think we were going to know the full scope of what we were dealing with for some time. We also talked about the fact that these are difficult cases and difficult stories to hear and grapple with for a number of reasons. One, of course, is the terrible stories you hear about abuse that kids suffered in state custody. What also makes it difficult is that this happened many, many years ago. And so cases involving sexual assault, especially, and cases involving sexual assault of kids are incredibly difficult to investigate and prosecute or to evaluate for purposes of civil litigation if they happened very recently. They're all the more difficult to address and deal with if they've happened many years ago. So we talked about that when we had brought this forward back in 2022. And then, of course, we talked about the difficulty of assessing really what the legal exposure is to the state when you're dealing with potentially, at the time, hundreds, and now over 1,000 cases. So I say all of that just to emphasize that I look at this as an incredibly important piece of legislation, and I look at this process as incredibly important for the state, not just to limit the state's exposure in litigation, but to make right what was a terrible wrong that was done to many kids in state custody. Of course, all situations are unique and all victims had their own experience, and every particular case needs to be vetted based on the facts of that case. But when you think of this in totality, again, it's difficult for a lot of reasons. We also recognized at DOJ that the traditional litigation process can be difficult, right? And that's what led to establishing this process. And based on all of those things, we recommended in 2022 that we establish this claims fund and settlement process as an alternative to traditional litigation, as an alternative to a process that can be very difficult for anyone who may have to interact with the court system, but can be especially difficult for someone who was the victim of physical or sexual abuse as a child. So the legislature passed HB 1677 in 2022, and it set up the process we have today. I am very, it can be difficult to find the right words, but I'm proud of the work that we have done as a state in current times to address this situation. I think that the state should take pride in the fact that we have confronted a wrong that took place many years ago, and that we are doing our best, as Senator Bradley said, to try to respect the need to compensate victims, respect the rights and dignity of victims while protecting the state's bottom line and the state's ability to budget. To date, we've resolved 147 claims for a total of about $71.5 million, and the average claim paid so far is about $486,000. That average has been pretty consistent throughout the process. So that just gives you a sense of the numbers. And I think while we can expect those numbers to continue to move, that generally falls, in fact, below the projections we made in 2022. So 147 claims resolved to date, $71.5 million, an average about $486,000. As counsel for Nixon Peabody, or counsel from Nixon Peabody for the plaintiffs mentioned, when we were having these negotiations back in 2022, since the process has begun, there have been three primary topics that have prevented many claimants from coming into the fund. The first is that the caps were too low. The second is that the scope was too limited. And that the third is that the process was overly complex and burdensome. So last fall, we began negotiations. We reopened negotiations with Nixon Peabody and Russ Riley because we wanted to take another shot at getting to agreement on something that could provide a fair and reasonable and more victim-centered and trauma-informed approach for the vast majority of the victims involved in this case. And we spent months with those negotiations. And what you see before you today is a product of difficult but respectful negotiations, sometimes contentious, but I think always conducted in good faith. So I want to certainly thank Nixon Peabody and Russ Riley, specifically Dave Vicinanzo, Mark Knights, Dan Dean. Certainly want to thank Attorney Cantor for her involvement in the process. And I want to thank those from my team who have been involved. Matt Broadhead is here today. Sam Garland is here today. Jen Ramsey here today. They're all with my office. And I certainly want to thank Senator Bradley and all the legislators involved at crafting what sits before you as a compromise. It is a true compromise in that there are pieces in this bill that if I could write the bill the way I wanted to write it, or write a settlement process the way I wanted to write it, I wouldn't have in there. And there are certainly pieces in the bill that if plaintiffs' counsel wanted to put, or that plaintiffs' counsel probably didn't want in there, and there are pieces that they wanted in there that didn't make it in. It is a true compromise that sits before you, and it is a collective best effort to address a very difficult situation. We do not claim it is perfect by any means, but what I can represent to you in my role as Attorney General is I think this is a very good faith effort to address a very difficult and complex problem and to make right a wrong that was done to many victims. So I don't want to repeat too much what you've already heard because Senator Bradley gave you a lot of details of what the bill does. I just want to hit a couple high points and then I'll be happy to take questions. But as I mentioned, one of the big issues with the current process is that the caps were too low. That was one of the issues that plaintiffs had raised. So this bill raises the cap for abuse that would fall into the category of egregious sexual abuse from $1.5 million to $2.5 million. There's a definition of egregious sexual abuse in the bill. It is generally defined as sexual abuse that is just of a nature that's much worse than most other instances of sexual abuse that you've seen from victims that have come forward who are at YDC. Ultimately, the determination will need to be made by the Administrator John Broderick. So there's discretion left to the administrator, but that's the general definition of egregious sexual abuse. There's a number of other factors listed in the bill that the administrator can look at to determine whether something's egregious. I won't read through them, but I'm happy to answer questions on them. The definition of sexual abuse was also expanded to include things like indecent exposure, invasion of privacy, a common law invasion of privacy. I just point out that not all sexual abuse is valued the same. So while the category of sexual abuse is expanded in the current guidelines, the worst forms of sexual abuse are valued at $200,000. And as you go down the list, the lowest value is $25,000. Saying all that, of course, it's important to acknowledge that there's really no dollar amount you can put on this type of abuse, right? And I think we all have sort of this gut negative reaction to even putting a number on something like this, but that is the way the law compensates for injury. It compensates with dollars, and so we're doing our best to put a dollar number on it. But in reality, no amount of money could ever truly compensate for abuse like this. As Attorney Cantor mentioned, we also expand sort of physical abuse. So we remove the category of physical abuse, and it now includes other abuse. So other abuse includes the physical abuse that's in the current process. So it includes what already was listed as physical abuse, but we add a few things like reckless conduct, criminal threatening, child endangerment, unlawful strip searches, intentional infliction of emotional distress, and unlawful restraint. Again, this is a compromise. I know when we talked about the bill in 2022, some of these categories of abuse we decided not to include, but we have, I would say, a couple things to that. One, we have a lot more information now, 2 years later, about what happened at YDC based on the claims that have come through. We've heard a lot of stories, and we have, it can be difficult to talk about these things in the abstract. You really get a better understanding of what happened when you hear stories from specific victims. And it was based on those stories and based on discussions with plaintiffs' counsel that we made the decision to include these categories of abuse. Again, the cap on other abuse is $250,000. So the cap on sexual abuse that's not egregious remains $1.5 million, while we have sort of expanded the other category from physical abuse to other abuse and added additional things. The cap goes up from $150,000 to $250,000 for that category, but it's still just $250,000. So I say that to just remind the committee that there's still sort of tiers of the values of the various categories of abuse. For solitary confinement, which was a major topic of discussion the first time we discussed this in 2022, the cap on that is $150,000. So we felt it was important to acknowledge those victims who suffered it in unreasonably long periods of solitary confinement. We felt that it was important to acknowledge and compensate for that. Plaintiffs' counsel have shared with us studies that show that can be really damaging to a child. But at the same time, we cap that number at $150,000. The other two big things that this bill does, and this again represents the compromise, in exchange for expanding the scope and increasing the caps, the bill now provides that the administrator can decide that a claim could be paid over a period of years. And the reasons for this are really two. One, there's a state interest in spreading out these payments over time, because while we acknowledge that we need to do the right thing by these victims and we need to pay fair compensation, there's a reality to what the state can do financially. And so this bill allows for some claims to be paid out over a period of years. It caps the administrator's authority, or I should say it obligates the administrator to monitor the fund balance and caps his authority to make payouts at no more than $75 million in any one fiscal year. That number could go up for a particular fiscal year if he comes and gets approval from the executive council and the fiscal committee, or I should say the governor and council and the fiscal committee. But it generally imposes that $75 million per year cap in order to enable the state to have some predictability. And then, as Senator Bradley mentioned, there's a 5% interest for payments made over time. The bill also addresses making the process more efficient, and really the major thing it does with that is that it removes some of the mandatory timelines or gives more flexibility on the timelines, but it also, and this is very important, removes the obligation of the Attorney General's office, the Attorney General's designee, to take a position on a claim before a claimant has had their hearing in front of the administrator. And the reason why that's important is this. Right now, we at the Attorney General's office take a position on a claim often before we've ever seen or heard from the claimant. And I think anyone who's worked with victims can tell you that without either you yourself talking to a victim or you yourself at least being able to listen to what a victim is saying, listen to what they have to say in their own words, hear them testify, it is very difficult to assess credibility and really think about how a claim should be valued. The way this bill changes the process, we will have much more of an opportunity to do that, to at least listen to a victim's testimony before we take a position on a claim. And I think that's going to be really valuable for the process. Again, the bill also extends the filing deadline to June 30th, 2025. I think that's going to be important because we're going to have to rewrite the guidelines. The last point I will make, and again, there's a lot more I could cover here, and I've already talked really longer than I intended to, but there's a lot of information here. I just want to make sure you have it because it's an important bill. But the last point I will make is this. I said it before, there's no amount of money that can truly compensate for what happened to somebody for abuse you suffer as a child. There's just no amount of money that can truly compensate for that. And there is an understandable desire from many people, and myself included, to want to be sure that we're determining what happened to each victim with enough certainty that we're paying the right amount of money. For a situation like this that involves so many victims, that happened so many years ago, we're never going to land on a perfect process, right? Perfection will never be something that we can achieve with this. But I think our goal as a state should be to make the best good faith effort we can to pay some fair compensation to people who suffered terrible abuse while in state care. At the same time, understanding that this is never going to be a perfect process, but we need to do the best we can. I think if we look at this legislation, look at this process with that philosophy in mind, then I think my hope would be that you would see the product you have before you as an attempt to do that and as a fair compromise among people who have really worked hard in good faith to come to a process that can be a good alternative for the vast majority of victims. With that, I'm happy to take questions, and I appreciate you listening to my long explanation and long set of remarks.
I just have a question. So as an example where the term egregious sexual abuse is in here, is this something that will just be a permanent new definition in statute?
No, so this is a definition solely for purposes of the YDC settlement process.
Okay.
So someday when this process has concluded, this statute will disappear. So this is not a permanent definition.
Okay, thank you.
Yeah.
Representative Newman.
Thank you, Madam Chair, and thank you for taking my question. I'm just trying to understand this. This is in a judicial process. This won't take place in court. Could you just give us a nutshell, like somebody files a claim?
Sure.
Then when do you get the testimony, and how does the administrator, and who is he, how did he get there, and what happens so that they go through and pick this one and that one and whatever to come up with a solution for that particular
Absolutely.
claimant?
Absolutely. Thank you, Representative. Yes. So this is separate from the judicial process. It's meant to be an alternative to that because I think as many of you probably know, or at least can ascertain, if you file a lawsuit, it takes years often to get it resolved, right? And this is meant to be a much more efficient way to resolve a claim. So at a high level, a claimant submits a claim form, and there's we went through this whole process in 2022 to develop what the claim form looks like. Claimant submits a claim form to the administrator's office. The administrator makes a determination on when it's complete. There might be a back and forth between the administrator's office and the claimant if there's missing information. And the goal is really to help get all the information in the form that's necessary to look at the claim. The way the process works right now is once a claim form is complete, it gets sent to the Attorney General's office, and the Attorney General's designee reviews the claim, and we take a position on what we think the value should be. And we can have a back and forth discussion with the claimant. And if we can come to an agreement, then we just settle the case. If we can't come to an agreement, then it's submitted to the administrator for a hearing process. And the administrator will ultimately make a decision on the value of the claim. The way that we value the claim and the way the administrator values the claim is by using the guidelines that we developed back in 2022. And those guidelines set out what different incidents of abuse are worth from a monetary perspective. So I hate to use the word formula for something like this, but it's kind of like a formula. So we use a worksheet, or claimant uses a worksheet. We kind of use the same worksheet. The administrator uses the same worksheet if he has to decide the claim. But that is at a high level, generally the process. Our goal is to have it take no more than 6 months.
Follow up.
Yeah, my only follow-up would be, so you have some kind of formula that was developed in 2022, and then this bill just amends the various values and things and puts in new definitions. So it's a combination of what you had in 2022 as amended by this bill, and then that process as you described it.
Yes.
Thank you.
And just to clarify for you, at risk of giving you more information than you asked for, the guidelines and the claim form that were developed in 2022, that was separate from the legislation. We had to draft those in consultation with Claimants Counsel and then get them approved by the Fiscal Committee. If this bill passes, we'll have to do the same thing because there are changes being made in the legislation. We'll have to go back through the Fiscal Committee, working with Claimants Counsel and now the administrator to amend those guidelines and that formula and that worksheet, and in order for this bill really to truly take effect.
Thank you. That helps a lot.
Yep.
Representative Harry Gathright.
Thank you, Madam Chair. My question is, the administrator, since they have the opportunity to make the decisions, the final decision, is there anything in there, say if a person is 60 versus 40, and just a question, if you're 60, your lifespan is probably a little bit shorter, and if you're 40, might be a little longer. So is there anything in there that says that based on age or something that that might help to form the decision whether to pay immediately or go over a span of time?
Yeah, so yeah, thank you for the question. I think it's a really good one. Yeah, it's ultimately up to the administrator as to whether to award a claim in a lump sum or have the claim paid out over a period of years. And while there's no set list of criteria that the administrator has to consider when deciding that, he has discretion. And I can tell you, in talking with plaintiff's counsel and talking with the administrator, I think that's certainly something that would be taken into account, whether someone is older or we have had claimants who might be ill and may not think they have a very long life expectancy. And I think in those situations, that certainly would be more likely to either be a lump sum or at least a payment maybe over 2 or 3 years as opposed to 5 or 6.
Thank you.
Yep.
Representative Pratt.
Hello, thank you for the questions. I have a question. Has anybody, since this all started, the reporting, has any children passed away? Has any of these 1,400 people passed away?
So I don't know that off the top of my head. What I can tell you is that the way the bill addresses that is once a claim is filed, if someone passes away, their estate can continue with the claims process. If you haven't filed a claim yet, the estate can't file a claim.
They can't.
But I don't know whether anyone has passed away. On that note, I can, and this addresses, I think, Representative Muse's question from earlier. Outside of this process, the Attorney General has the authority to settle any case. And the cap is actually, it's quite a bit higher than Senator Bradley mentioned. The cap is all the way up to, I think it's, 1/4 of 1% for a particular claim or case, 1/4 of 1% of the previous year's general fund revenues. So that's about up to $5 million for a case. So we have a lot of flexibility to settle a case even outside of this process. And we would always consider, the job of the Department of Justice is always to consider the interests of justice. And if there were a unique case like that, we would certainly, or for that reason or for another reason, we would consider using that authority to do justice and provide some compensation.
Thank you.
Representative Sytek.
I can't resist. Did Formella develop the formula? Would you agree that the most important part of your testimony is that the administrator is John Broderick?
I would say that, I think it's important that the administrator is someone like John Broderick, who served as the Chief Justice of the New Hampshire Supreme Court and is, clearly, I think, respected in the bar. So yeah, I think that who the administrator is always an important question. And yes, the fact that it's John Broderick, someone that the state trusted to be the Chief Justice of our Supreme Court, should give people confidence that this process will work.
All right. See no more questions. Thank you very much for your testimony today.
Thank you.
Is there anybody else wishing to testify on this bill that is not turned in a pink card? Seeing none, I will close the public hearing for Senate Bill 591. And I will open the public hearing for the non-germane amendment, Senate Bill 563. And I'm going to recess Senate Bill 563 until Monday, April 22nd at 10 o'clock. With that, I will close that public hearing. And our business for the day is done.